please file it in the department. Leave is granted, leave is granted.
Yes,
File it.
can leave granted, file it.
My lord, in this matter, Lordship was pleased to dismiss the appeal for default, my lord. But unfortunately, along with the appeal, the trial court matter also got dismissed. Only that part, my lord.
In the order dated July 22, 2026, erroneously, we had recorded that the ASFC 3 of 2005 was also dismissed. Push up. Let the said order be deemed to stand corrected by deleting the words within double inverted along with ASFC 3 of 2005 and inserting in place of the same double inverted is double inverted close. Let this order be deemed to be a part of the order dated July 22, 2026.
Grateful, Lord.
Sorry. Yes. Next. Yes, Mr.
May please, Lord.
Yeah.
To volume 2 টা দেবেন, only volume 2. 183.
The next one is mine.
Thanks. Yes, Mr. Ghosh. No, the other Mr. Ghosh, senior Mr. Ghosh. Yes. Yes.
That's why after
Yes. Literally.
My lord, just to remind you, Lordship, of the basic fact. The suit property belongs to CPT, now KPT.
Yes.
Lolita Sadhu Khan was lessee under CPT.
Right.
Lolita Sadhu Khan is a paternal aunt of the respondents, admitted in the evidence.
Yes. Yes.
Then Lolita Sadhu Khan devised the property in favor of the respondents for a certain period, and the lease was to expire for 10 years, expiring on 8/2/1975. The respondents in turn subleased the property to the appellant for a period of same period, but and expiring on the same date. When the lease expired by flux of time, Lolita Sadhu Khan gave a notice that you have to quit and vacate to the respondents. Respondents in turn gave a notice to the appellant that you quit and vacate because the lease has expired. What is the legal position then? Both of us are tenant as sufferers or trespassers. That's the legal position, both respondents and appellant. Then, my lord, we were occupying the premises. Nothing further happened. They filed this suits, my lord. I don't know whether Lolita Sadhu Khan filed this suit or not against the respondent. Respondent filed a suit against us. Then, 91 or 92, rather, I should say, sometime in the month of August, the Calcutta Port Trust, this was then CPT, came to take possession of the suit property on the ground that they were executing a decree of eviction against Lolita Sadhu Khan. They did not find Lolita Sadhu Khan. We moved an application before Justice Mitra immediately that please protect us, because all of a sudden we are faced with this predicament. When Justice Mitra gave the order, I've shown you, Lordship, that order. Then up to this, all documents have been disclosed. Then, in the broader picture, when we go back to the City Civil Court, we were served with a notice under Order 21, Rule 97 by CPT. A proceeding was against Lolita Sadhu Khan, who was not found in the suit premises, and also against us against the appellant for resisting. This was then the appellant for the Order 21, Rule 97 proceeding by filing objection. And all those documents, matters of record, which they said they don't mind, whatever appears from the record, I'll place. So it appears then Lolita Sadhukan has suffered a decree way back in December 1979 in a suit instituted by CPT against her only in 1974. All these were suppressed. Then this decree was put in execution on the 12th year. In the 12th year, just before it's going to be bound by limitation, CPT woke up. Then we said, what is now? If you've suffered a decree in 79, why didn't you surrender the tenancy? Then we could have made our arrangements. And because all of us are trespassers then, including Lalita Sadhu. She had no right to bring in a suit. That's why she didn't bring in a suit. So all of us, but as I said last time, my lord, that except us, I'm not saying the appellant was also a trespasser, but because of Justice Betra's order, I got some protection. This is the basic facts. Now, my lord, if you place the document, the judgment before your lordship, and what I said from these documents in the city court proceedings are all annexed to the Order 41, Rule 27, which will give your lordship a complete picture for proper adjudication of the disputes between the parties. Order 41, Rule 27B.
Yes.
As I said, my lord, I will only deal with the judgment now. The judgment cannot stand, my lord.
Yes.
The judgment starts at page 276. Well, the appellant's submission or the defendant's submission it starts at page 286.
Yes. This was placed also. The judgment was placed also on the online.
Now,
Highlight whatever you are.
only highlighting the portion.
Yes, Mr. Because you just
That's why I'm assailing this.
Yes, right.
My lord,
Because we have our markings also. We see.
Yes.
Your
I'm
arguments.
on the first day, on the opening day.
Yes.
But I cited the main point they took, AIR 1985 Calcutta, that if you want to make complete disruption with the lessee and lessors between plaintiff and defendant, or the appellant and respondent,
Yes.
appellant sublessee must go out de jure and de facto to disrupt the relationship. This was totally disagreed by the judgment, not this, but the proposition was to the contrary. I have cited these judgments at page 286. And three of those judgments have been approved by Supreme Court. Now, my lord, next point is kindly come to page 288.
Yes.
Right at the bottom, last 4 lines.
Right.
Such claim of the defendant was founded firstly upon the notice of eviction issued by Lalita Sadhukan to the original plaintiff and the defendant, whereby Lalita Sadhukan terminated the tenancy existing between her and the original plaintiff, who are the respondents before the lordship. Second, foundation of defendant to the contention they were not required to vacate the suit premises in spite of the sublease expiring by flux of time, and the notice to quit was the order dated, and the notice to quit was totally, I think this is wrong, whatever the learned judge. Notice to quit was the order dated 24 September 1992, passed by this Honorable Court in the writ petition. This is wrong. This portion is totally wrong. Then, so for 116, my submission method was there that it at the very inception of the tenancy I cannot challenge, but during the subsequent events I can always challenge the title of the landlord.
Yes, yes.
That was my submission. And these are the judgments I had cited. Krishna Prasad Singh has been extensively quoted in subsequent judgments of Supreme Court. Then, my lord, kindly come to page 291. Fourth line. This was it. The estoppel disappears. However, if the landlord's title was extinguished subsequent to the inception of tenancy, or if there was eviction by the title paramount.
We marked this.
Basic
On the,
principle, my
yes,
lord,
yes.
which I want to say.
And you also highlighted that in the next paragraph, the right of the plaintiff is not extinguished merely by suffering the notice of eviction.
Yes.
The original plaintiff was not evicted by title paramount.
Yes.
This was what you highlighted also.
Yes. Plaintiff was not. Then, my lord, kindly come to the last 6 lines
Yes.
of this judgment. The original plaintiff was not evicted by title paramount Kolkata Port Trust. Also admittedly not evicted by any of the parties from the suit premises. Totally wrong, because when an eviction Port Trust came to take possession pursuant to an execution proceeding, they had only one person with whom they had privity. That was Lalita Sadhukan. The judge, of course, I could not place the documents because my client was unable to produce them at that time. He just totally dementia. I've said so. I've got the certificates, medical certificates also. So it is obvious. It was obvious, and that was my submission to the learned judge. The Lalita Sadhukan has suffered the decree. We can't, because we had no privity. If Lalita goes, all of us go. We can't say. So this is totally wrong, my lord, by the learned judge. Kindly come to my lord. That's why I said that Order 41, Rule 27 documents are so important. Take the last line at page 293.
Yes.
Plaintiffs were not, the respondents, evicted by Kolkata Port Trust authorities from the suit premises. The plaintiff respondents were nowhere figured in Kolkata Port Trust, so-called melody in the papers. It's only Lalita Sadhukan with whom they had privity. Then, page 294, last paragraph. From the facts, it would appear that the plaintiff was in possession of the suit premises. Wrong, my lord. I strongly disagree. Because we were carrying out, the appellant was carrying out business as JK Pure Oil Mills. No one else. Neither Lalita nor by the respondents. This is totally wrong. All this actually were totally supernumerary for the simple reason, if the decree against Lalita was produced, that would have solved all the problem. That would have solved all the problem, because we had all then had no right to occupy the suit premises. Lalita Sadhukan, respondents, and the appellant. Unless the appellant, till the appellant was protected by Justice Mitra's order. Then, kindly come a little, I'm reading on, page 295, top line. They were inducted in suit premises by virtue of the deed of lease dated 16 December 1965. The deed of sublease also expired by flux of time. No doubt, Lolita Sadhukan terminated the tenancy of the original plaintiff. Nothing on record was shown to suggest Lolita Sadhukan took possession of the suit premises or had initiated any proceedings for eviction against the original plaintiff, or that any decree of eviction was executed against the original plaintiff in respect of suit property at the behest either of Lolita Sadhukan or Kolkata Port Trust. Totally below, this is where the judge, had he examined the order of Justice Mitra, because obviously they came to execution proceeding in a decree of eviction. And Lolita Sadhukan's decree was passed against her. That's why Justice Mitra made it very clear, except appellant, nobody else can remain in possession. KPT can execute the decree. It is obvious, very obvious from the order itself, that's why the appellant approached the writ court. Then, my lord, kindly come to the next paragraph. Next paragraph, no, my lord, say, my lord, 6 lines from the bottom. The plaintiff was not evicted from the suit premises. Number 1, this is error. The defendants failed to establish, that is appellant, that their relationship with the plaintiff, respondents, stood disrupted de jure and de facto. In such a scenario, the defendants were stopped under Section 116 from contending that the plaintiff did not have any title to maintain, did not have any right, it should be, to maintain the suit for eviction. Now, we'll kindly come to page 296. This is very important. The order dated September 24th, 1992, passed in writ petition on writ petition number 3194 of 1992, allowed the KPT authorities to take appropriate proceedings for eviction in accordance with law upon prior notice to the defendant number 7, who was appellant. It was not the case of the defendants that subsequent to the order dated September 24th, the KPT authorities had initiated any proceedings for eviction upon notice to the defendant, number 7. There was no embargo of KPT authorities to initiate proceedings for eviction. Such order could not be read to mean that the plaintiff would not be entitled to evict the defendants for all time to come. Where does this matter? This is completely, totally devoid of any way of law. In fact, they have been evicted already. They stood evicted. The second contention of the defendant was also without any basis. If KPT is the only person who can evict me, nobody else. The learned judge didn't give any right to the respondents who are rank outsider trespassers. A trespasser cannot come and initiate proceedings that you go out when I'm staying there with the right given to me by the Honorable Court. This portion, my lord, is totally devoid of any question of any principle of law. So, my lord, the judgment itself suffers from various infirmities which cannot stand. Now, my lord, the judgment, the order of Justice Banerjee, I've shown your lordship several times. Now, if your lordship kindly takes the দেখি হ্যাঁ হ্যাঁ it's by issue এই যে order 41 rule 27 এটা পিটিশন ছিল না Here your lordship will find
Yes.
the ejectment suit was instituted by CPT on number 144 of the 1974 against only Lalita Sadhukan, nobody else. He prays it at page
Yes.
6. Kindly take the decree for recovery of possession of the land described so and so, so and so.
Yes.
This was defended by Lalita Sadhukan. The written statement was filed by Lalita Sadhukan
Yes.
at page
30.
30. Filed by defendant. Then, my lord, I've given all the orders passed from time to time. All this. This suit was decreed. That will appear at page 54, my lord. This recorded suit has been decreed.
Yes. No. Fifty-four is a summons.
Page 35.
35 years. 35 years. That is
Now, my lord, kindly come to order 21, rule 97, petition to page 48. My lord, kindly come to page 48.
yes.
Kindly see there, my lord, the first title. This is the miscase number 1230 of 1992. Plaintiff decree holder is Board of Trustees for the Port of Calcutta. Judgment debtor defendant, judgment debtor is Lalita Sadhukan. 2. Balaram Sadhukan, register.
Yes. Yes.
Then kindly see the petition. May I read it out, my lord? That on 7th September 1992, that's about 2 p.m., Shanath Kumar Ghosh, land inspector of the plaintiff, accompanied by court bailiff, went to the south. Went to the south side of Crossroads, so and so, being the Well, may I ask Mr. Gupta to read it out to your lordship?
Mr. Ghosh, apparently a point was taken that the decree is a nullity because of the provisions of the 1971 Act.
Oh.
Because it has been pleaded here that 1971 Act provides the provisions for decree of eviction, and here the City Civil Code as a civil code has directed it, and therefore
That is unauthorized occupation.
Unauthorized
Public
occupation.
premises, unauthorized
Yes, the
occupation.
trappings of that act should have been applicable, but the civil code passed the decree. Para 5, you say it's a null and void decree and not enforceable. Para 5, you say that, and accordingly, you say that this should be
That
done.
was an objection, my lord.
Because in the nature of a section 47, apparently.
We did not so.
Nullity and.
No.
If you please come to para 5 of this application, Mr. Ghosh.
Yes.
It's pleaded, opposite party number 2 pleaded, not you, obviously.
Appellant pleaded. This is mine.
You are.
I am opposite party number 2.
Right, Sadhukan, sorry. So you have pleaded that this.
One of the points we had taken.
Yes.
One of the points we had taken. Eventually, it's a longish opposition we gave.
That is what we are trying to do, cut it short.
We eventually got this proceeding were dismissed or default.
Great. Let us move on then.
And all these proceedings will there kindly come to
Dismiss or default was not restored.
no.
So, Mr. Ghosh, let us proceed. Move on. I mean, then Order 21 Rule 97 you have annexed also for police help.
Yes, everything goes. Main point is we were only in possession.
Yes, yes.
Nobody else. Now, my lord, may I show the case laws? Now, my lord,
Please, absolutely.
what have we put here? 2000, distinguished, the year 1985, on which there's the only judgment cited by the respondents before the trial court. Each court. What?
There is only judgment which is not here.
Cited, they are just trying to.
It's referred to in the impugned judgment.
140.
It's extensively quoted here.
Yes, it was.
Finally come to page 141.
Right.
2002 area, 2002 Calcutta, page 144.
Yes.
I will come, my lord. Kindly come to page 151, para 25. Because the question here was, could you institute a suit even before the time, efflux of time? And that question was the suit is maintainable or not. During the pendency of the suit, the lease comes to this. That's one of the points here. But
in your case, that is not the case.
No, but then I just to show you, the question is sufficient to allow the appeal. But since the other points have been urged and our judgment is subject to appeal, this court proposes to decide other points in view of the mandate of the Supreme Court in measures Formants Resorts and Hotels Limited versus Gaston Ranto Cruz Pinto, reported in AIR 1985, Supreme Court 736.
And Order 14 itself also. Order 14 itself also.
Yes.
Even if it can be decided, other issues to be decided.
The next question is, was the tenants estoppel under section 116? Then, I'll kindly come to paragraph 27. The section came up for interpretation before the Judicial Committee. No, it's page 116 has been quoted in para 26. Para 27. The section came up for interpretation before the Judicial Committee of Privy Council and the Supreme Court in one of the early decisions in the case of Barbani Coal Concern, AIR 1937 Privy Council 251, Sir George Rankin, speaking for the Judicial Committee and after considering the analogous principles of English law, explained the rationale behind the section as follows, page 391. Kindly, may I come to the, I will not trouble your lordship.
The underlined portion, Mr.
Yes.
That's the crux of the. So we were thinking whether we should be impudent enough to request you to come there directly. So please come there. So we have seen that. Yes, definitely that's the law. No
Then-
doubt on that.
Then para 28.
Yes.
In explaining the principles of section 116, the learned counsel appellant first relied upon decision of D. Satyanarayan versus Jagdish Prasad. And they set out, but the facts are a bit different there.
Hmm.
In the background, the immediate landlord then commenced eviction proceedings against the Satyanarayan under section 103 of AP Buildings Lease Rent Eviction Contract Act, Control Act, on grounds of default and so forth.
Hmm.
In the background of these facts, the Honorable Supreme Court in para 3 said as follows. The appeal must be allowed on a short question that there being a threat of eviction to a person claiming to a title paramount, that here the head lessor, Krishnamurti, the appellant was not stopped under section 116 of the Evidence Act from challenging the title and right to maintain the eviction proceedings for the proceeding of the respondent P. Jagdish. This was, beloved, eventually, but all these cases have been cited. The important point is this. Whether you can be para 39. Kindly come to para 39. Mr. Dutt was appearing for the respondent. The learned counsel for the respondent relied upon the division bench judgment of Calcutta High Court reported in Ganesh Trading Company, AIR 1985, Calcutta, page 37. The learned counsel relied upon the judgment in order to point out that eviction of by title paramount does not take place by mere filing of suit. The learned counsel relied upon para 6 of the judgment in Ganesh Trading and contended that even a decree or an order for possession by itself cannot constitute eviction by title paramount. The learned counsel pointed out that the learned judges in Ganesh Trading held that in order to constitute such eviction, there must be actual disposition, maybe by delivery of symbolic possession, in consequence of the decree or order for possession. So the learned judges in Ganesh Trading have held, in order to overcome the rule of estoppel, it is always necessary for the lessee to establish that his relationship with the immediate landlord stood disrupted not only de jure but also de facto, which the trial judge in this case also relied upon. In arriving at the forced conclusion, the learned judge relied upon a passage of Spencer, Bauer, and Turner, and the passage has been quoted, but I need not tell you lot. It's quoted there. 10, 41. This quote with profound and deep respect for the learned judges delivering the judgment in Ganesh Trading is unable to agree with the views of their lordships expressed in paragraph 6 of the judgment. Possibly Ganesh Trading the attention of the learned judges was not drawn to the subsequent paragraph, to the subsequent statement of principles by the learned author in the aforesaid treatise of Spencer Bauer at paragraph 203. The learned author has said, have developed the principle of eviction by title paramount by stating that actual physical disposition or expulsion from is the most obvious and um, ordinary form of eviction. But but learned authors stated that the eviction may be proved by this. It is sufficient to prove facts and proceedings on the part of the third person to establish that the property submitted by the tenant, which may tantamount to unanimous actual possession by force. The learned authors have distinguished distinction of such execution by stating principles as follows. Is established by proof that there exists a third person claiming title paramount to the demised premises, and that this third person has threatened to evict the tenant unless the atonement or pays to rent or make a new arrangement with himself, and that such atonement payment arrangement may be made by the tenant in reasonable apprehension that the threats and demands of the tenant are warranted by title paramount and not made by capriciously or in collusion with the landlord. Then they have stated below various.
Halsbury was also quoted.
Halsbury is quoted.
Similar proposition.
Kindly come to para 47.
Yes.
So, in view of the principles above, stated, elaborated in Spencer Power and Halsbury and for landlord and tenant, which have been pointed out above, that the law laid down in para 4 of D. Satyanarayan Supra, we hold with utmost respect to the learned judges that the principles laid down to the contrary in honest trading cannot be followed as a binding precedent. These principles may be read confined to the facts of that case. It may be noted that the subsequent judgment of Supreme Court in S. Sankapat, AIR 1999 Supreme Court has approved the ratio of D. Satyanarayan. So, a complete dissension by a deficient bench. They went on a wrong passage of
Spencer's, Halsbury. Yes.
Wrong principle. So this is totally it's approved by. I must point out one other thing.
Para 48 also says it is necessary to show atonement or some arrangement between the tenant in possession and the superior landlord. That is also in para 8, para 48.
Yes.
That also has to be shown.
That has to be shown. But here that question does not arise. Because there is already eviction decree. There is already eviction decree. We were all misled before the trial court. If they come out.
Sir Ghosh, as per para 48 of this judgment, apparently, even if there is a threat of eviction, there is no actual disposition. In that case, but in order to show eviction by title paramount, it is necessary to show atonement or some arrangement between the tenant in possession and the superior landlord.
And the title paramount.
Title paramount. So here, what is that arrangement or?
Title paramount here, first of all, there is complete eviction here. There is no question of.
They were not there in possession at all.
At all, non-Lolita. So far, some arrangement, it can be said that Justice Mitra's order.
No, that Justice Mitra order is not an arrangement between the tenant in possession and the superior landlord. Here it says there has to be an arrangement shown between the superior landlord and the tenant in possession.
Yes.
There is no such arrangement here.
No.
Para 48 insists upon that also.
Well, only one thing. We gave a letter, not one letter, several letters and checks to accept us by to atone the tenancy to us.
But there was no consensus ad idem on both sides.
No.
On that.
No.
So there was the arrangement between the
But
superior
I
level
am
and-
only citing this judgment for the purpose that the judgment relied upon in
So 85 you are distinguishing. So
absolutely
that could not be relied on by the trial court.
trial court. And you're
But
not,
while distinguishing, Mr. Kushi, you also have to deal with para 48 of this judgment.
yes,
Because it has to be read as a whole. It distinguishes 85, but puts in a further rider at page, para 48, page 154 of this judgment, the one which you are placing. Justice Ganguly's judgment. But in order to show eviction by title paramount, it is necessary to show atonement or some arrangement. That is also there.
kindly come to paragraph 4. But in order to show eviction by the title paramount, it is necessary to show that atonement or some arrangement between the tenant in possession and the superior landlord here the said atonement or agreement has not either been pleaded or proved, but the threat of eviction is there in view of the suit being filed by Walcher and Hedlesson. The main question which has, so here they don't say about arrangement or anything.
But then that is diluted in para 49.
The main point which has been lost sight by the learned trial court is that the date of when this decree was passed in the plaintiff had lost the right to be. This is in the facts of this case. This is in the facts of this case. Because HON'BLE case, that's in Calcutta Street.
Yes.
Union Bank was a tenant, and this person was subtenant.
Some of us owe our robes to Vachal Mullah. So, yeah, we have to be careful of what we.
So this is on facts of this
Right.
case.
Right. Very.
But 48 below is quite clear. 48 is quite clear. I will kindly come to my learned jury points out at page 155, left-hand column, continuation of para 49, last 4 lines.
Yes.
But in view of subsequent events, it is open to the appellant to deny the title of the plaintiff respondent to the effect that the plaintiff has lost his right to remain in lawful possession of the suit property. So, below, the atonement portion actually below has not been dealt with subsequently. So the judgment which the learned trial judge relied upon and based his judgment is totally wrong on a wrong principle. Kindly come to para 3 first, Spirit, at page. I'm now citing the Satyanarayan versus P. Jagdish of the Supreme Court.
Which was relied on in the previous judgment.
1980, yes. 1987, 4 SCC 424. Kindly come to para 3
Yes, yes.
from the 5th line. With P. Jagdish as result. Section 116 of the Evidence Act provides that no tenant of immovable property shall, during the continuance of the tenancy, be precluded to deny the landlord of such tenant had At the beginning of the tenancy, a title to the immediate property, to the immediate property. Possession and permission being established, estoppel would bind the tenant during the continuance of the tenancy and until the surrenders of possession. The words during the continuance of the tenancy has been interpreted under the tenants in question, and the courts have repeatedly drawn to that estoppel operates even after the termination of the tenancy, so that the tenant who had been let in possession, however defective it may be, so long as he has not openly surrendered possession, cannot dispute the title of the landlord at the commencement of the tenancy. The title of estoppel is thus restricted not only to extent but also to one in time. That is restricted to the title of the landlord during the continuance of the tenancy. And by necessary implication, it follows a tenant not estopped when he is under threat of eviction by the title paramount from contending that the landlord had no title before the tenancy commenced or that the title of the landlord has come to an end.
And Mr. Ghosh, with utmost respect to all these judgments, there are two components of Section 116. One is that during the continuance of the tenancy, you cannot deny, and at the beginning. Now, at the beginning is not dealt with here also. Now, even therefore, by necessary implication, first of all, if during continuance of the tenancy, you cannot deny. All these judgments focus on continuance of the tenancy, whether the tenancy was terminated, and all these things. But even during continuance of the tenancy, you can deny subsequent loss of title. That has been lost sight of in this.
That was Justice Rankin's point.
And the section itself, if the section is very specific, two components. Even during continuance of the tenancy, you can say that at the beginning he had title, but subsequently he lost it. I can say that even during my tenancy, continuance of my tenancy, I can say subsequently
I think
he has lost.
In paragraph 4.
Yes.
4, I think, Your Lordship.
Right. However, defective so long.
The law of
No, but this also relies on during the continuance of the tenancy. That is the focus of all the judgments. So during the continuance of the tenancy, if you come to the fifth line of para 4, Mr. Ghosh, during the continuance of the tenancy, the tenant cannot acquire a prescription.
No, but placitum here, middle of that page.
Yes, you are right. Thus, a tenant not from denying the derivative type.
From this exception follows, it is open to the tenant, even without surrendering possession, to show that since the date of the tenancy, the title of the landlord has come to an end and that is evicted by paramount title holder.
Yes.
It is KPT. Or that even though there was no actual eviction or disposition from the property, under threat of eviction, he is atoned to the paramount or whatever it is.
Here it is laid down crystal clear.
Yes.
Even without actual disposition. Yes. Right.
Now, before we read this, in 2003, one thing I must tell you a lot. Yes, I am accused later on. This judgment of Justice Ganguly went up to the Honorable Supreme Court. 144. And this judgment is reported, the Supreme Court judgment is reported in 2005, Volume 4, SSC 315. Supreme Court only dealt with the question of maintainability, did not touch the question which Justice Ganguly talked about, the paramount title and for the position to be given up or not. That portion left alone. They said the suit is maintainable. I can tell you, Lordship, I've been through. I need not trouble you, Lordship, with that time. Lordship can take it from me. This point was not at all disturbed by the Supreme Court.
Yes.
Next judgment, my lord, I would like to cite 2001, Volume 6, SCC 512. You all charge Mimani versus SK Sen. This is about the Ongla Hut. Yes. Time 35. Too. Just give me 1 moment.
In fact, in a transfer property scenario, Mr. Ghosh, probably under section 111A, in any event, tenancy determines one of the modes of determination is
First point
efflux
is
of
A.
first point A. So therefore, what remains after that? Why do you, in a rent control act scenario, Mr. Ghosh, absolutely eviction would be necessary, decree would be necessary. That too a decree, because the definition of a tenant is that whoever is entitled. Once a decree is passed, there also under 1956 Act or 97 Act or other rent control laws of Delhi, Bombay, whatever, in all of those, once a decree is obtained, the relationship is severed.
Absolutely.
So there is no continuance of the tenancy. Execution is only a mode of giving a culmination to that enforcement. We cannot determine the strength of the decree by the enforcement phase. Enforcement is a ministerial act in a sense, unless 2197 to 101 comes.
1 point here, it said, if you're out of possession, court will not put you back in possession.
Yes, all right. That is also there.
That is also there.
That is
Here, they have never been in possession. KK was run by Balaram Sadhukant throughout.
Balaram's position has been recognized, if you may say, in Justice N.K. Justice Mitra's order and the other, your application, their objection also to that.
The suit says that I am in possession.
Exactly.
Be evicted.
Yes, precisely.
The last judgment below this, year 2025, Calcutta 534.
Last judgment, you have seen the most relevant portion.
Which one? This one.
The last judgment, you have seen the most relevant portion.
Then your lordship could have omitted that.
So, but this is also unstable what we were saying all along. I mean, that has been held here.
So throughout, this is what I want to show you.
So subsequent loss of title of landlord can be 116 at the inception. That's the same thing.
Much stronger footing here. Because there's a decree of eviction. The moment they came before the writ court saying that I am being evicted by CPT, the learned judge gave me only against me, not any other can be evicted.
Appears to be so, yes.
And the learned judge and the trial judge said, how come that was my submission also, that there in an ejectment proceeding, execution proceeding, somebody must have been evicted.
On 116 Evidence Act, you probably have a very strong case. We're not commenting on the others. This is subject to what Mr. Chaudhary says ultimately. But
no, I'm talking about so far my contention was that even if I could not place the documents before the judge, he said there's no evidence that suit has been filed or that there's any proceeding taken. The very fact that the CPT came to take possession from me in execution of a decree of eviction against with whom CPT had privity, only with Lalita Sadhu, nobody else. And that is borne out by the petition under Order 21 Rule 97. Execution was launched against Lalita initially No, respondents were nowhere in picture in any of these things.
All right.
Then we came as a register, and Lolita never appeared throughout.
But your right was not independent from this parent, from the middle lesser, intermediate lesser.
Because they
Not independent. You were in a sense, you were inducted as an agent of the middle lesser.
they are all after the flux of time.
Yes, that is your case.
All of us became
That also went. Yes, all of
all
us.
of us are trespassers.
All of you, yes.
All of
All
us. I'm not saying I'm not putting my client at a higher level.
Cannot be. Yes.
I am also a trespasser. I was. But that's why I had to rush to court when they came to take the property from my possession.
Hmm. Hmm.
That's why I'm on a bit. This case is on a bit of. I'm on a stronger footing here. And I beseech your lordship to take these documents into account so to do complete justice between the parties relating to the disputes.
These documents under Order of 27 are mostly certified copies and
Only certified
part and
copies.
records
only
also.
certified copies.
Not new documents, new evidence as such.
No.
All are pleadings and
And
certified.
they
copies.
said, if even except appears from the record, and what appears, we deny all other allegations.
Yes, obviously.
So they have accepted
Yes.
those are my so
Thank
my the appeal should be allowed.
Thank you so much. We have taken the citations on a later date. We will fix a later date after hearing Mr. Chaudhary and your reply for written notes.
For
Just for written notes of arguments, very brief.
okay.
Nutshell so that we don't miss out on any. And that will be a bullet point notes of arguments. You have taken our notes also.
That's what I got.
Soft bullets.
Bullet point.
Yes. You just have that printed. That would suffice. Yes, Mr. Chaudhary.
Well, we are talking about the law
Yes.
pertaining to eviction by title paramount on a sublessee.
Hmm.
Now, my lord, the law was recognized or settled for the first time in 85 Calcutta, short judgment of Justice Anil Sen, and my respectful submission that law still stands today. That's my first submission. My second submission is, with greatest of respect, my lord, the division bench judgment presided by my lord Justice Ganguly, my lord, my learned friend today has conceded, it has been set aside by the Supreme Court, and the judgment of the single judge restored. I'll rely on the judgment of the single judge, Justice Ajoynath Rai, which has considered the principles of Ganesh and has dealt with how title is, what is the law relating to eviction by title paramount. And I don't need to show judgments that once a judgment is set aside, it is not on what ground it has been set aside. So far as precedentiary value is concerned, it is effaced. And I'll also indicate that Justice, the division bench judgment presided by Justice Ganguly, perhaps, my lord, has misread the English, my lord, those Halsbury and Court, and has gone too far or given too much importance on absence of actual disposition in construing the ratio laid down in Ganesh trading. I'll come to that. This is the easier part of the job. The harder part of the job is I have to dispel a notion, because, my lord, I came across a judgment of my lord Justice Bhattacharya, the senior Justice Bhattacharya, in Charu Diesel, and what fell from your lordship just now, making a distinction between principles protected in case of rent control statute vis-a-vis transfer of property act. My lord, don't take me amiss, but my lord, I will try to persuade your lordship
that we are wrong.
My lord, there is no such distinction. The Supreme Court has, in fact, Justice Lahoti, all the judgments at that relevant point of time are of Justice Lahoti, my lord, has categorized a tenant in sufferance, my lord, both under the rent control legislation as also under the transfer of property law. Lordship, while presiding, my lord, in another division bench, has taken a slightly different view, saying that what may be true for rent control legislations, because the relationship is not severed till a decree intervenes, would not hold true for Transfer of Property Act principles. Lordship gave an example just now, 111A and all that. Lord, that distinction is, my lord, irrespective if a lease is determined under 111A, and my lord, I shall rely on judgments, and this is also there in the classical texts of Amir Ali on evidence and all that. My lord, we hear the expression tenant at sufferance.
Yes.
And Lordship has also heard a tenant at sufferance is slightly on a higher pedestal
Trespasser.
than a ranked trespasser.
Yes. Somewhere in between.
It may be a short-lived right, but slightly on a higher trespasser,
Because the
higher pedestal.
entry was not a backdoor entry.
Correct.
If you may use Uma Devi here. Yes.
Now he continues to be a tenant at sufferance, and tenant at sufferance gets a further higher pedestal under 116 of the Transfer of Property Act, not Evidence Act,
Mhm.
of the Transfer of Property Act.
Mm.
If the landlord accepts the rent from the tenant at sufferance, then my lord, holding over principle comes. 116. So my lord, tenant at sufferance, he continues. Now the question is, can a sublessee, what is the obligation of a sublessee vis-a-vis the lessor? Lord, the law is well settled and lordships have noticed that. And my lord, in my respectful submission, that is the law both in cases covered under Transfer of Property Act as well as cases covered under the rent control legislations, that you can come under or surrender, my lord, to the title paramount or have a relationship with title paramount only under two situations. Number one, the actual lessee has surrendered the possession, and thereafter the sublessee is tendering rent, you are getting attorned. This is number one. Number two, there is eviction of the actual lessee, execution done, and you are getting immediately executed. In execution, you will be immediately evicted. Then you are coming to some sort of a fresh contract with the title paramount. Otherwise, I come and settle in the execution. These are the only two situations under which a sublessee can have a direct nexus with title paramount.
That was touched upon in para 48 of Justice Ganguly.
But it has come in many of the judgments.
No, because we are criticizing that also. So therefore, 48, to be fair to Justice Ganguly's judgment, vis-a-vis your argument, 48 touches that.
Yes.
But then it dilutes.
With respect, my lord, that judgment, my lord, it has gone on a totally different principle. I am not required to go into that because, my lord, good, bad, indifferent, my learned friend has fairly said, my lord, I'll first start with that Supreme Court judgment. Lord, kindly takes 2005 4 SCC 315.
Yes.
Lordship already has it, so because I was armed with it, I thought.
No, that I don't have. That is
my learned friend.
on the.
He referred to it. My lord,
My
lord, kindly take copies.
He referred to it. Mr. Ghosh referred and said that it was on mint.
My lord, this is in appeal from the judgment of.
Yes, Justice Ganguly.
It kindly comes to the first paragraph. I'll read two paragraphs. It was set aside. My learned friend is right. It's set aside on a different point, but it is a more fatal point because, my lord, Justice Ganguly had held that the suit is also premature. First issue was premature, not maintainable, because you file the suit before the lease comes to an end. There was, when they say that they are entering into a transaction with the sublessee and all that, the lease period was still there. So, my lord, the suit was dismissed on the ground that it is premature. Now, on that principle only, not only it was the single judge's judgment was again brought back, and I'll come to the single judge judgment, which discusses, in my respectful submission, the correct position of law. following the 85 Calcutta principles of Justice Anil Sen, which, my lord, according to my respectful submission, still holds good. Let kindly take the first paragraph. In respect of a property situated in metropolitan city of Calcutta, a lease of immovable property for a fixed term commencing on 1st April 1964 and expiring on 24th June 1984, evidenced by a registered lease dated so-and-so, came into existence. Lessee entered into possession of the lease premises on 1/4/64. On 26 September 83, the lessor served a notice on the lessee, informing the lessee that the tenancy was to expire on 24th June 84, and therefore on that date, the lessee must deliver vacant possession of the demised premises. On 8 November, the lessee sent a reply taking a firm stand that he would not vacate the demised premises in terms of the lease deed, and the request contained in the communication dated 8 November 1983. The lessee also disputed the entitlement of the lessor to claim possession had itself come to an end on account of eviction by a paramount title holder. On 16th April, the present suit was filed by the lessor. Then, my lord, the reliefs have been quoted. Then, my lord, paragraph 2. Suit was filed 12 weeks before the date on which the lease was to expire by efflux of time within the meaning of clause A of section 111 of Transfer of Property Act. Written statement filed on 24th August 94. One of the pleas taken in the written statement that suit was premature and hence not maintainable. Then, my lord, I am not troubling your lordship with the analysis of the pleadings. Let kindly, my lord, straight away come to, I am sorry, my lord, paragraph 4. By the judgment of 12th February 1992, my lord, I shall shortly place this judgment. The High Court decreed the suit, holding the plaintiff entitled to decree of eviction with a preliminary decree directing an inquiry to ascertain the mean profits. The plea as to non-maintainability of the suit on account of its being premature was decided against the defendant by the learned single judge of the High Court, placing reliance on Rangaya Naidu versus Basanna Simon. In the opinion of the learned single judge, no prejudice was caused to the defendant on account of the suit having been filed a little before the expiry of lease by efflux of time, inasmuch as even theoretically the suit could have been disposed of before 24/6/1984. It would still be open for the court to pass a decree of eviction and made the decree executable only after 24th June 1984. The defendant preferred an intra-court appeal. The division bench has reversed the judgment of the learned single judge and directed the suit to be dismissed, holding it premature, as it was based on a cause of action which was not ripe on the date of institution of the suit. Feeling aggrieved, the plaintiff has filed the appeal by special leave. Then, my lord, the court goes into the question whether it is premature or not.
But Mr. Chaudhary, something we are speaking against you in favor of Mr. Ghosh's argument. Para 6 says the sole question arising for decision in this appeal is whether the suit was premature.
Correct.
So that is only what was considered. Although the entire judgment was set aside, now there are two things. One is between the parties, the judgment is set aside, it's no longer binding. But the precedentiary value regarding that, if it's stated by the Supreme Court, recorded by the Supreme Court that it's entered in on a sole question and that is decided, what about the other
No, my lord,
which was laid down?
kindly come to para 24. My lord, then this is what I was saying. Then I'll have to cite a judgment. Once a judgment is set aside, my lord, lock, stock, barrel, it is not that, my lord. It may be, my lord, on a preliminary point. The Supreme Court was not required to go into it.
No.
Because, my lord, what is done is, my lord, kindly see para 24. That is all is relevant over here. Kindly see para 24. And, my lord, we can't go into the minds of who had argued, my lord. It may be, my lord, this was a more basic point, and, my lord, that was not into. But, my lord, it is well settled.
Yes.
Once a judgment is set aside, my lord, it is not that, my lord, paragraphs, some paras remain and some paras do not.
No, the judgment goes as a whole, no doubt on that. And what you say is correct, that was a part of the ratio of this judgment.
Correct.
But
And,
that
my
is
lord,
not.
I will independently deal with the reasoning of
Precedential.
Justice Ganguly,
Yes.
otherwise also.
We are trying to distinguish between the binding effect on the parties, which is no longer there if it is set aside as a whole, whatever may be the ratio. and on the precedentiary value, the ratio of the judgment, whether that remains a binding
My lord,
precedent, is not specifically satisfied.
I will try to, by way of submission, my lord,
Yes.
make a point
Hmm.
that once the single judge judgment is restored,
Yes.
and my lord, I show the reasoning, and then I show why the appellate court has gone wrong. Because now in this situation, I can show your lordship why the appellate court went wrong, because the appellate court judgment
Not
is
there.
no longer there.
Not there.
Otherwise, I would have difficulty.
Understood.
That is why I am showing.
Understood.
Well, at para 24,
Yes.
the appeal is allowed. The judgment and decree passed by the division bench is set aside, and instead the judgment and decree dated 12 February 1992 passed by the learned single judge is restored. However, the defendant is allowed time till 30th September for vacating the suit premises subject to filing. So, my lord,
Entire judgment. set
entire
aside. No
judgment
doubt.
has been set aside.
Yes.
Now, my lord, I cite the single judge judgment, which
Yes,
is, my lord, 1990 AIR 1992 Calcutta 283. But kindly straight away come to paragraph 6. The point to my mind is well settled by authorities and
We'll
hardened.
start from para 5 for
Very
completion.
well, very
Yes. Yes. The point is
The
set out.
point in this suit is whether a subtenant, like the defendant in this suit, can resist the claim for possession made by its immediate landlord against it on the basis that this landlord has lost title or right to possession under the lease by way of which the immediate landlord was originally holding the property. The point to my mind is well settled by authorities and hardened principles of law. A tenant, insofar as he claims as a tenant, is not permitted to dispute the title of landlord from whom his tenancy and possession have been derived. This is a rule of estoppel expressly enacted in the Evidence Act itself. On that basis, even a trespasser landlord can maintain a suit for eviction as against his tenant, and it would not be open to the tenant to challenge the title of the landlord in any manner whatsoever. The reason for this long-standing rule is simple to understand. The tenant comes into possession from and by reason of the landlord. As such, he shall hand over possession to that person from whom he originally came to acquire it, and shall not raise pleas or obstacles in that regard. It little matters whether the lease of Vithalbai with Washal Molla expired on 25th June 84 or 24th June 84 was one day prior or subsequent to the date of expiry of the lease of the defendant Union Bank of India. The defendant is not entitled to inquire about the original title of the admitted landlord Vithalbai Private Limited, and a claim for possession cannot be resisted on the ground. It may appear at first flush that a person who is apparently not entitled to retain possession with himself is obtaining a decree for possession as against another person. It might be a matter of surprise to the lay mind, but to the legal mind, it does not present any contradiction. The law is well aware of relative rights arising as amongst different parties based on relationships amongst the parties themselves. As between the plaintiff and the defendant in this suit, the defendant cannot resist a claim for possession. That does not in the least mean that the right of Vithalbai to obtain possession as against Union Bank of India is a right that can be enforced by Vithalbai in rem in respect of the demised property. The decree as against Union Bank binds only Union Bank of India, and the same cannot be put into execution, could be put into execution against Union Bank or others claiming through it. On this basis, the question of Vithalbai's original title clearly appears to be a matter of complete irrelevance. Then, my lord, the earlier judgments have been referred to. Well, let's straight away kindly come to, well, it otherwise makes interesting reading, my lord, lordship will, my lord, one of my favorite judges, if I may say so, not because, my lord, sometimes he has gone totally
A bit feudal.
on a different line,
A bit feudal.
but this is, my lord,
A bit feudal, Mr.
and my lord, this is
You are also a bit feudal.
Let kindly come to my lord para 15.
15 years. We are speaking about the views, not the persons.
Yes, yes.
Absolutely. Yes.
With regard to amendment, one Supreme Court case was relied upon, that is case of Ganesh Trading reported in AIR 78 Supreme Court 484, and reliance was placed upon para 5 of the report. Nothing appears from a whole reading of the case to throw any doubt upon the validity of the amendments that were permitted to be incorporated in the plaint. These amendments were incorporated when the defendant, true to its representation, did not vacate the premises upon arrival of 25th June 1984. The claim for possession was already there. Accordingly, the expiry of lease was put on record, and a statement and a claim were inserted for the purpose of claiming mean profits. I am of the opinion that such introduction of subsequent facts and subsequent claims have already been pronounced upon in the grant of permission of amendment given by Justice Banerjee in his Lordship's order of 27 February. Such amendment clearly did not introduce any new cause of action or change the suit in any manner, but merely was a consequent right upon apprehension of the plaintiffs turning out to be right that the defendant would not vacate upon expiry of the lease. Then my lord straight away kindly comes to
Yes.
paragraph 17.
Hmm.
I again express my inability to see what that defense might be. It little matters to the defendant whether the plaintiff was a trespasser or a monthly tenant or a tenant continuing in possession after expiry of lease. The estoppel against the lessee would operate equally well and with equal strength in each of the above three cases. And my lord, this law still holds good. There has been no dilution in this principle of law. A monthly tenant might, vis-a-vis his landlord, have no right to give a sublease of 21 years or of 22 years. But if that sublease is granted, then after the expiry of that term of 21 years or 22 years, the sublessee cannot turn back and plead in defense the original monthly tenancy of his immediate landlord. That is prevented by the rule of estoppel mentioned above. And my lord, what I started, my lord, this rule of estoppel, it does not really matter whether this principle is applied in statutory rent control tenancies, which has a peculiar mode of determination, erstwhile section 13, now section 6. You may have additional grounds, and also, my lord, vis-a-vis, my lord, the various modes in section 111.
No, we must clarify this, Mr. Chaudhary. You are probably, did not meant what you were trying to say. There is absolutely no qualification of section 116 or the rule of estoppel vis-a-vis whether it's a rent
Correct.
control. No, we are not saying that at all.
No,
116
I am making this qualification, my lord, because I will try to show after expiry of your original right.
Our point is when, 2 points. Because, just to help you.
Yes.
Because 116 equally applies in both cases. There is no doubt on that. Cannot be. The question is whether, because another language has been used in our section 116, we are not looking at English law. We are Indians, we are looking at Indian law. 116 clearly qualifies it by also saying that cannot dispute the title of the landlord or lesser whatever at the beginning of the tenancy when he was inducted. That is also there. So that cannot be disputed. Vis-a-vis that, we are trying to look at when this tenancy expires. So in a Transfer Property Act case, Mr. Chaudhary, if it is by efflux of time, 111A operates immediately. Without it, that was our point.
I've got your point. Because of that expression, that since the statute is saying during the subsistence of the agreement, they can perhaps dispute it after the agreement comes to an end. That is, my lord, what is?
Two things. One is, during the subsistence of the relationship, he cannot dispute.
That is what, that is the, my lord, if he disputes that, my lord, his own
tenancy goes. But what can't he dispute? That also section 116, if you read the language, states that he cannot dispute the title of the landlord at the time of induction, at the time of commencement of the tenancy. So thereby, by a plain reading of section 116, Mr. Chaudhary, there cannot be any reason why even during the subsistence of his tenancy. I mean, obviously that would automatically go if the title goes. Subsequently, he has lost title. That I can. Why can't I say?
Right.
You
Well,
also deal with that
Millard,
vis-a-vis the judgment.
Millard, the principle of estoppel
Yes.
proceeds on the premise.
I was inducted at that point of time. He had title.
That
I
is
have
all right.
title.
That is all right.
Subsequently, what happens?
Millard, the entry point, Millard, again, Millard, all laws relating to eviction,
Yes.
Millard, it is dealt with, Millard, the point of entry, the entry point. When you are coming in, what is the position? That is how, Millard, all the law proceeds. Now, on a principle of estoppel, Millard, Lordship knows the classic rule is a representation is made,
Act is
you
done
act
under.
on that representation
To your
and
detriment.
alter your position to
Your
your
detriment.
detriment.
Yes. Yes.
So long as you are in the property, you are acting on
advantage.
that representation.
Taking advantage of this. Yes.
And that representation continues till such time you go to the person making that representation and say, here it is, I no longer want to be in the property, take back.
All right.
Look, this is the basic pillar of, fundamental pillar of estoppel, that a person is altering his position to his detriment based on a representation. And that is why, beloved, Lordship will find universally this principle, notwithstanding the limitation in statute, beloved, has been extended vis-a-vis sublessees and sublessors all across high courts and even Supreme Court, that no, once you come into the property holding the hand of person A, you cannot later say that I don't recognize that hand, whatever may be the situation. Because decree will operate, my lord, in terms of this. Well, it is not something in rem in personam, that so far as landlord and tenant is concerned, or lessor and lessee is concerned, sublessor and sublessee is concerned, my lord, this becomes a permanent principle. Because
license and licensee.
Because, my lord, it is again, my lord, of the fundamental principle of estoppel, that you have acted only on this representation. You have not acted on the representation. Well, he has 5 years left. After 5 years, I will come and take over the property. In this way, I can enter into a circuitous arrangement with the landlord. This is not the representation. And that is why, my lord, even the law pertaining to eviction by paramount title holder, the eviction decree simpliciter will not suffice. Execution proceeding mere filing will not suffice. Threat of eviction in execution proceedings. Bailiff has come, then you go and enter into some sort of a settlement in the execution proceedings, my lord, you have to put it that high. That as if I am entering into a fresh contract at this stage. And, my lord, universally, it has been discouraged that you cannot, the sublessee cannot go and enter into a direct negotiation with the lessor so as to remove. My lord, here these facts are more glaring. Here, my lord, Order 41, Rule 27, I shall show that it is on record. They brought it on record in the subsequent, my lord, when the mean profit proceedings were going on. Execution proceedings were also dismissed in 2005. They have brought it in evidence. But at that stage, there was no question of going back to the decree. It made their case worse. What benefit of doubt, the cloud they could create by saying there is an eviction decree, this was not brought on record, we were not allowed to, I had a memory lapse and all that. Because they had brought it on record. Eviction proceeding dismissed in 2005. When did they leave the possession? After the decree of the learned single judge. After the decree impugned, that is much later, 2022 or 2023, they hand over direct possession because they thought by this way they would save their liability of mean profit. And in a way they are right, because I could have otherwise, I was on the verge of negotiating an independent right from the port because, they were successful in orchestrating whatever they did. That has been jeopardized, but I will have it my way after I get the mean profit. This point has been done what? This is the fundamental difference, in conduct. Kindly, ask the first question while adjudicating this case. When did the appellant hand over possession to the port authorities? After they suffered a decree.
Yes.
But I shall give your lordship the date. Now, my lord, even if they had done it, my lord, in course of when they are contesting my suit, that also doesn't protect them. Because as on the date when the learned judge passed the decree, my lord, the question which will arise is, could that decree been executed at all? Answer is no, 12 years have passed. Could there be a fresh execution application? Answer is no, 12 years have passed. So it's really a red herring which is being brought before this honorable court, which actually has no significance. So whether, well, in my respectful submission, Order 41, Rule 27 is not required to be gone into, because Exhibit 1 is already on record. Well, kindly have a look. Well, I'll come back to this judgment. Kindly have a look at Exhibit 1, which should be at page 93 of Volume 1. And I'll show the question also by which this was introduced. Of course, before the special referee, but it is nonetheless there. So, Exhibit 1, Small Causes Court, the order sheet is at page 95. And this was their evidence action.
Yes.
Page 95, order dated 9th June 2005. OP's file Hajira. No step is taken by the decree holder. Application on behalf of so and so filed at 2:30 p.m. Today is fixed for filing show cause by decree holder. No cause is shown by decree holder. Hence, it is ordered that the miscase filed by the decree holder is dismissed.
This was the order 2197.
This is, my lord, in execution. And, my lord, this is their evidence. Lordship will see, my lord, Exhibit 1 was tendered before the special referee. My lord, Volume 2, page 480, I believe. Yes. 479, my lord, the examination in chief starts. My lord, kindly come to page 480. Question 5. Are you aware the decree which was sought to be executed by the Port Trust against Lalita Sadhuka? Yes, under the proceeding of Order 21, Rule 27, miscase before so and so, so and so. Question 6. What is the present status of this execution proceeding? That was dismissed. Witness volunteers in year 2003, miscase was transferred to presidency where it was renumbered before the learned special court. Shown certified copy. Is this the order of dismissal that you are referring to? Yes. Is the original order? Yes. Tendered and marked Exhibit 1. We did not object to that also marking. So, my lordship need not look into that main decree over here because execution has already been dismissed. And as on date of passing of the decree in this suit, there could not have been any threat by the title paramount holder, either by reason of decree or it was non-executable. It was a paper decree, it is no value. And that is why, my lord, advisedly they did not earlier bring it on record or, my lord, keep it, my lord, behind the clouds. Now, my lord, I come back to, I'm sorry, my lord,
This will resume. Yes. Yes, please.
My lord, I was on the judgment of the learned single judge,
Yes.
Justice Ray.
That's
That this was also a case under Transfer of Property Act. Paragraph 3 makes it clear. And will the ultimate conclusion, let paragraph 17, Lordship is pleased to come.
yes, 17.
I again express my inability to see what that defense might be. It little matters to the defendant whether the plaintiff was a trespasser or a monthly tenant or a tenant continuing in possession after expiry of lease. The estoppel against the lessee would operate equally well and with equal strength in each of the above three cases. A monthly tenant might vis-a-vis his landlord have no right to give a sublease of 21 years or 22 years. But if that sublease is granted after the expiry of that term of 21 years or 22 years, the sublessee cannot turn back and plead in defense that the original monthly tenancy of his immediate landlord that is prevented by rule of estoppel mentioned above. In view of the above, first 6 of the 7 issues raised on part must be answered in favor of the plaintiff. Issues raised were as follows, and then, my lord, other there was no dispute, so my lord, decree for eviction was passed. Now, my lord, let us consider the parent case. In fact, not the parent case, but my lord, the most referred case, my lord, so far as our High Court is concerned, my lord, AIR 85 Calcutta, page 37. What? My lord, I shall furnish a
Yes, yes.
photocopy.
Notified.
Now I have the.
This is a Justice Sen's judgment.
Yes.
Yes.
My lord, very short judgment, but my lord, I think it covers the entire point that, my lord, we are also today faced with. My lord, kindly straight away come to para 3. I am sorry, my lord, para 4. Mr. Dasgupta, appearing in support of the revisional application, has raised only one point in support thereof before us. According to Mr. Dasgupta, the effect of the order for possession, as was upheld by this court in CR 158 of 82, is to determine the title of the lessee as such, and such an order for eviction constitutes eviction by title paramount. The point thus raised by Mr. Dasgupta has been strongly contested by Mr. Mukherjee, who is appearing for the lessee. The short point that arises for our consideration, therefore, is as to whether the order for eviction, as passed against the lessee by itself, determines the lessee's title to realize rent from the sublessee, and whether such an order, even before its execution, can constitute eviction by title paramount. On a careful consideration of the point so raised, it appears to us that such a point is no longer res integra. Such a point was specifically raised before a division bench of this court in the case of National Jewellery 63 CWN, and this court in express terms upheld the claim of rent of a lessee who has suffered a decree for eviction, but yet had not been evicted in execution thereof. Mr. Mukherjee has rightly drawn our attention to 2 other decisions supporting the same view. In the case of Adhanath Ghatok versus Krishna Prasad Singh, AIR 49 Privy Council, the Privy Council held that for a tenancy between A and C stood determined not by the decree for eviction obtained in 1925 against A, but by execution thereof in 1928. The view taken by the learned trial judge is fully supported by a decision of the Madras High Court in the case of Bhagavatullah K. Rao versus Mungara Sannyasi. A point was raised by Mr. Mukherjee that under the provision of Section 116 Evidence Act, the sublessee is estopped from disputing his lessor's right to realize rent in the facts and circumstances of the case. On our finding, as regards the continuance of the lessor's title to realize rent until actual eviction by virtue of order for possession, the question of estoppel loses its importance. So a distinction is made on actual eviction pursuant to a decree and that. Even then, we cannot but observe that there is ample substance in this contention of Mr. Mukherjee. It appears to us to be settled principle that though under Section 116 Evidence Act, the lessee is precluded from disputing the title of his lesser at the date of the lease, he is not precluded from pleading loss of title of the lesser subsequent to the induction as a result of eviction by title paramount. But in our opinion, a mere decree or order for possession by itself cannot constitute eviction by title paramount. Well, this is what the learned single judge has also taken into account, that even if I take your best possible case, the decree more than 20 years have passed, nothing has happened. I read it again. But in our opinion, a mere decree or order for possession by itself cannot constitute eviction by title paramount. In order to constitute such eviction, there must be actual dispossession, which may be by delivery of symbolic possession in consequence to the decree or order for possession. Mr. Mukherjee has rightly drawn our attention to the following observation from Spencer Bauer's estoppel by representation. The estoppels which mutually bind a landlord and tenant are estoppels by convention, and when the lease is de facto as well as de jure disrupted by the process of eviction by title paramount, there can be no injustice in allowing a tenant to establish this fact, and indeed this has always been allowed, and the tenant permitted to use evidence for the purpose of extinguishing completely any right to estoppel which the landlords might previously have enjoyed. Thus, to overcome the bar of rule of estoppel, it is always necessary for the lessee, in the present case the sublessee, to establish as a fact that his relationship with his immediate landlord stood disrupted not only de jure but de facto. Well, here the de facto element is completely missing. And not only missing, just keep this judgment in hand. Kindly have a look. They in 2014 write a letter to the port trying to say that you accept rent directly from us. Well, that is Exhibit 2. I'm sorry, Exhibit 3.
What is the date of that?
26 September 2014, page 97, volume 1. Because, my lord, it dawns upon them, execution proceeding dismissed in 2005.
That was to port.
Yes, to port. And this has been, my lord, repeatedly it has been deprecated. You can't do that. Because they are seeing that, well, I have not been evicted. It's almost 10 years now. So let me see if I can steal a march and have a direct relationship with port. At page 97, Estate Manager, Kolkata Port Trust. Lord, I am not troubling your lordship with the entirety of the letter. Kindly see one paragraph, page 100, the last paragraph. I pray that you will be graciously pleased to consider my case and grant direct tenancy in respect of the property. I'm sorry.
No, we got.
Well, it starts at page 97.
Yes, we got.
Well, in fact, kindly come to page 99. And kindly see paragraphs 8 to 11. This applicant came to know, well, it has referred to the miss case. Applicant came to know Srimati Lolita Sadhukan requested by a letter asking you for statement of outstanding rent in respect of the property. I raise strong objection to such letter allegedly signed by Lalita Sadhukan, as she is 78 years old, suffering from several ailments including neurology, so and so. Moreover, she has no locus standi over the property. That previously the applicant approached you for a long-term lease directly to the applicant in respect of the property to run business smoothly. Well, these are admissions which are shocking. 93, 2001, 2011. No question of my learned friend submitted, it's a threat. This is what they were trying to do. That is the fact that you have settled many cases by granting direct tenancy. I undertake to pay all legitimate dues lying unpaid till date and calculated. Therefore, I pray you will be graciously pleased. So they will not pay mean profit to me. Instead, they were trying, I will make payment to the court and I will circuitously, I will steal a march. And my lord, this judgment in Ganesh Trading, my lord, this still holds field. And my lord, it has not been diluted. In fact, my lord, if now lordship sees, my lord, again I read, my lord, Justice Sen's judgment. Kindly come back to paragraph 6. Mr. Mukherjee has rightly drawn our attention to Spencer Bauer. Here it includes, my lord, kindly see, symbolic possession also is there. I could have understood, my lord, my learned friend's case would have been on stronger footing if, my lord, their client would have written a letter. Well, I am occupying possession through this. I am handing over symbolic possession to you. Please don't execute the decree further. Give me fresh terms. I'll do it. Bauer is recognizing. The distinction made by Justice Ganguly's judgment is that it is not applicable. The attention of the division bench was not brought. Actual disposition may not be there. But I am also not saying that actual disposition. But it is on two principles. You have to surrender it on the threat of eviction in the teeth of an execution, that I go away. And Bauer is also recognizing this. Mere filing of a decree or an execution proceeding, not enough. And on their own evidence, execution proceeding dismissed in 2005. After 10 years, you are trying. In between, you have tried your luck. You failed.
So you mean to say, Mr. Chaudhary, in another sense, that the underlying refrain is that you cannot continue to take advantage of the juror relationship which you entered into.
Correct.
And in the same breath, simultaneously seek this. So then you go out. You surrender whatever you got by dint of that juror relationship, and then you ask for a.
Because under section 108, that P, after a lease, you have to surrender it to me. Because had they paid the huge mean profit, which has been decreed now to me, I would have perhaps been able to, my lord, rescue my lease with the port, which unfortunately, that's a different aspect. I have given a different advice. I am not on that. What step to, because they directly go. And when do they surrender, my lord? After the single judge's decree or near about that period. They don't come, my lord. They did not do it in the entirety. 2005, they were well aware. That is why, my lord, in this suit, when it was, my lord, they consciously chose not to come up with this document because they very well knew there is no threat of eviction. The execution proceedings have been dismissed. More than 12 years have passed, or at least near 10 years were about to pass. And today, the question doesn't arise at all.
But the letter which is marked as Exhibit 3, that discloses the fact.
Correct.
So it was not.
Yes, that letter, yes, it has come through them.
It was your exhibit.
No, their exhibit.
Exhibit 3,
Milord,
plaintiffs.
this is coming in.
Plaintiffs.
No, this is coming. Milord, in the original site, Milord, it is marked the reverse.
Oh, yes, yes.
Exhibit A, B, C, D, alphabet series for the plaintiff and number series for the defendant. Just the reverse.
So we forgot because we are dealing with appeals from district courts also.
Yes.
Right.
So,
Yes.
and this had come in when? This had come in when a decree for eviction passed. Special referee passed a order, an assessment. Special referee's report came before the court. This is the evidence before the special referee. My lord, they disclosed all this by way of evidence. Then after this, the court considered and passed a monetary decree as well. This is the second round of litigation. 20? Well, exact date my advocate on record is not aware, that they can only say, but it was in end of 2023 or early 2024 they have surrendered to the
After suffering degree.
After suffering.
So that is what you have said we have recorded. That remains.
Or my lord, near about end of 23 or 20.
Either after or before. That becomes important.
Well, decree is of
No.
Decree is of 2014.
So much after then.
Decree is stated 6 May 2014.
So therefore this remains, that
Yes.
handed over person to KOPT after suffering degree.
The judgment is 6th May 2014. And in September they are trying to.
So after remains, we are not changing that to near about.
No, after.
Yes.
Now, well, the next judgment that I cite.
Yes. Mr. sorry, Mr. Chaudhary, will you come back to this judgment, or we are handing over this later on?
Yes, my lord, I'll give a photocopy.
Yes, yes. It
But I read the entire, it's a 7-paragraph judgment, my lord, but succinctly it has, my lord,
That's the same. Yes.
justice said.
Right.
Justice said, my lord, just digressing for 30 seconds. But I did not have occasion to appear before him, and neither perhaps, but I did have occasion to appear before him in
Arbitration,
arbitration.
yes.
And my lord, we would make our arguments and come back. He would sit there alone with his stenographer, and the next day when we would return, the minutes would record whatever argument, and be it how long, it is 2 hours or 1.5 hour argument, 2 to 3 pages that would be summarized, and it would be given to the parties to say that, see whether all your points have been covered or not. And my lord, all the counsels on both sides would be surprised by the fact that we did not argue this well what has been reproduced.
Succinctly put in.
Succinctly.
Yeah.
And he would do it after everybody has left, not in front of the parties. He would make his note and say, any point left out, you couldn't even touch a pen on that. All points covered, and with the brevity that we could not imagine.
Yes.
Well, at the next judgment I cite, this is apropos in a case of, my lord, what is the position? I'll come back, because, my lord, law is well settled so far as rent control statute, my lord, the concept of tenant in sufferance, and, my lord, this principle of estoppel continuing till such time you are actually not evicted, my lord, that is well settled. This is a Supreme Court on Transfer of Property Act. My lord, this is reported in, this is of course a Manupatra citation, Manu SC 742 of 2002.
Is the naam ki?
Ashok Bimal Ghosh versus Beyant Kaur. I am giving a copy to my learned friend. হ্যাঁ আছে, অন্য সাইটেশন আছে, আমি দিয়ে দিচ্ছি। হ্যাঁ অন্যগুলো আছে, এটা মানুপাত্রার, বাট
এটা কত ভালো PIR এসেছে।
খুঁজে পাইনি স্যার, এটা তো এখন পেলাম, নিশ্চয়ই আছে ওগুলো, আপনাকে এটা দিয়ে দিচ্ছি আমি। আপনার আছে? হুম। But kindly come to straight away paragraph 6.
Yes. আমারটা mark করি বাস।
This would answer the, this I have taken it out to, my lord, answer the query which fell from your lordship, my lord, slightly earlier.
Yes.
Having heard the learned counsel for the parties, we are satisfied that no case is made out for interfering with the order of the High Court, rejecting the revision and upholding the rejection of review application by the trial court. It is not disputed that the respondent landlady had inducted the tenant appellant into the property of the suit premises. Under section 108, clause 1, clause L of the Transfer of Property Act, it is the obligation of the tenant to pay or tender rent to his lessor at proper time and place. Under clause P, on determination of the lease, the lessee is bound to put the lessor into possession of the property. Clause 1 and P of section 108 of Transfer of Property Act are to be read along with section 116 of the Evidence Act. No tenant of any property shall, during the continuance of tenancy, be permitted to deny the title of the lessor to such property. The rule of estoppel contained in section 116 of the Evidence Act continues to operate so long as the tenant has not surrendered possession of the tenancy premises to his lessor, or unless evicted by the holder of title paramount, which is not the case here. The trial court rightly decreed the suit upholding the entitlement of the landlady, so and so. But this is also a case under Transfer of Property Act. And, my lord, so, my lord, 2 points are well settled. These are the 2 cases: either you surrender possession, or you are actually evicted, or you are negotiating a new deal in the teeth of.
এসো, evidence act গুলো দাও। Yes, Mr. Chaudhary, please continue.
Because my lord, lordship will find if lordship takes the Transfer of Property Act.
এটা একটা দাও, এই উপরে যাচ্ছে।
Transfer of Property Act, my lord, section 108.
Yes, yes.
My lord, kindly come to clause Q, right at the bottom.
Yes, we remember that. You have to hand over possession.
On the determination of the lease, the lessee is bound to put the lessor into possession of the property. Now, my lord, this is why I am, my lord, venturing into this is apropos, my lord, a query that, my lord, in fact, my lord, my submission would be that the regards of the Transfer of Property Act is much more than the rent control legislation. Rent control legislation, my lord, law presumes, my lord, some sort of a protection. Because
Absolutely, transfer property is much more rigorous in favor of the lessor.
yes, here,
It's a cloak of protection. It's called a cloak of protection.
here,
under
if you have taken it from me, you are to return it. You
IQ
can,
and Justice Rai.
you have taken it from me, you are to return.
Yes.
And my lord, this I am only citing because, my lord, I came across that view in that diesel judgment, my lord. In fact, I formally cite it also. Lordship can reconsider that view.
Yes. No, that has been cited. Charu.
I've cited.
Charu
I
has
have-
been
then-
cited,
then
so
it
we
is
have a copy, so we
yes.
can argue on that.
Yes,
But
then it is all right.
Yes.
My lord, kindly see para 32.
32. Of Charu.
Yes, my lord. Paragraph 32 of Charu. Lord, I am looking at the neutral citation. I am looking at the neutral citation. I do
Just
not.
check whether the paragraph is.
It starts with, in fact, in para 7 of Vasudev.
Yes, paragraph tally.
Yes, my lord, if I may read from para 31 and 32.
Yes, please.
The plaintiff respondent 1 has cited Vasudev in respect of section 116 of the Evidence Act. However, such reliance is misplaced. The premise of the said judgment was that Rajasthan Premises Rent Control Act, which was a statutory tenancy, was created, and unless a decree of eviction is passed against such a tenant, it cannot be said that the tenancy has been terminated. Unlike the said case, a lease under Transfer of Property Act on its expiry by efflux of time or otherwise, as contemplated under section 111 of the Transfer of Property Act, automatically determines. In fact, para 7 of Vasudev, while examining the meaning of eviction by title paramount, the Supreme Court considered Krishna Prasad Singh versus Adhanath Ghatok, reported in so and so, where it was held that to constitute eviction by title paramount, no physical disposition is necessary. But even in Justice Sen's judgment, where that passage has been quoted, no physical disposition is necessary. If the true owner is armed with a legal process for eviction, which cannot be lawfully resisted, even though the tenant is not put out of possession, the threat to put him out of possession followed by atonement amounts in law to eviction. An exception to the requirement of actual physical disposition was also carved out in para 9 of the judgment, where it was considered whether landlord's tenancy had not come to an end by operation of law. In para 10 of Vasudev, the Supreme Court held inter alia that paramount title holder must be armed with such legal process of eviction as cannot be lawfully resisted. Since the said case was governed by rent control, where a tenancy can be terminated only by a valid decree of a court, it was held that mere threat of eviction would not suffice. However, by dint of exceptions carved out in para 7 and 10 of the said judgment, as discussed above, to constitute eviction by title paramount, no physical disposition is necessary if the true owner or paramount title holder is armed with a legal process of eviction which cannot be lawfully resisted. My lord, whichever way lordship looks at it, my lord, my first submission would be, my lord, the law is the same for both Transfer of Property Act and, my lord, rent control legislation. My second submission will be that even if we take it as a standalone finding or an independent finding, here, my lord, there is no question of not lawfully resisting it. There is no threat of eviction when the decree was passed. More than 12 years have passed even from the dismissal of the execution proceedings. And defendants gave possession willfully nearly 10 years after the decree, or more than 12 years after the decree. They tried to negotiate an independent deal, they failed, and then they give possession, and then they come and say that, look, threat of eviction. Well, this will even on the ratio of my lord Charu Diesel, my lord, it doesn't help their case. I am making twofold distinction. Yes, my lord, I should also read para 36
Yes.
of Charu Diesel. Yes. Thus, it was a typical case where appellants were armed with a legal process for eviction which could not be lawfully resisted. To constitute eviction by title paramount, as held in Vasudev, no physical disposition is necessary if the paramount title holder is armed by a legal right to dispossess, here under 111A. Thus, on expiry of the head lease and the lease granted in favor of the plaintiff, the sublease between the plaintiff and WEBEL Bebel also stood determined, and the head lesser owner through the appellant lessors were armed with the legal right to dispossess the plaintiff as well as Bebel. As such, Bebel was not barred under 116 of the Evidence Act from disputing. My lord, here, my lord, I am only saying, my lord, Lordship will consider the ratio of 85 Calcutta. It not only has to be de jure dispossession, but de facto.
De facto.
And my lord, formally, I cite the Vasudev judgment, which is of course on rent control, but the principles remain. And the second reason for citing this, my lord, is this is 2002 2 SCC, page 50. My lord, this, because my learned friend has formally cited D. Satyanarayan, that has been cited by him today itself.
That was approved in this.
D. Satyanarayan, my lord, kindly distinguished. Kindly come to para 13.
2 SCC page.
2002 2 SCC, page 50. 50.
Yes.
I'm sorry, para 13, my lord. I made a
No, you said para 13. You said para 13.
My lord, before I place para 13, kindly come to paragraph 6 once. We now proceed to examine whether the appellant could have directly atoned to the owner trust, bypassing the respondent tenant on 1st April 1983, relying on the event of institution of suit for eviction by the owner trust against the respondent tenant on 3rd March 83, and whether the said event enables successful raising of the plea of respondent tenant's eviction by paramount title, bringing the obligation of the appellant subtenant to deliver possession over the tenancy premises to the respondent and to pay rent to him till that date. Under section 108 clause Q of the Transfer of Property Act, in the absence or local usage to the contrary, it is an obligation of the tenant to put his lessor into possession of the property on the termination of the lease. Section 116 of the Evidence Act, which codifies the common law rule of estoppel between landlord and tenant, provides that no tenant of the immovable property or person claiming through such tenant shall, during continuance of the tenancy, be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title to such immovable property. The rule of estoppel so enacted has three main features. The tenant is estopped from disputing the title over his landlord over the tenancy at the beginning of the tenancy. Well, the second part is very important. Such estoppel continues to operate so long as the tenancy continues and unless the tenant has surrendered possession to the landlord. So till you surrender possession to me, if you have taken it from me, that estoppel continues. By dint of 108, then 116, evidence is not the whole lot. Then, my lord, kindly come straight away to para 13. How now, my lord? That has been distinguished. So I don't have to distinguish it separately. Para 13. We may now deal with the Satyanarayan case relied upon by the learned counsel for the appellant. A suit for eviction from the demise premises was decreed under 10(2) of the Andhra Pradesh Rent Control, which provides for eviction of a tenant if the tenant has denied title of landlord or claimed a right of permanent tenancy, and such denial or claim was not bona fide. The limited question arising for decision before this court was whether the appellant was estopped from denying the title of the lesser under section 116 of Evidence Act, despite the fact that there was threat of eviction by the owner of the demised premises by a person having title paramount, so as to examine whether such denial could be said to be bona fide or not. There was no dispute on facts. The statement of facts as set out in the judgment of this court shows that the appellant was constrained to attorn in favor of the original lesser. The High Court had upheld the decree of eviction passed by the trial court, resisting its judgment on the rule of estoppel. This court stated that the rule of estoppel and set out the well-settled exceptions to which the general rule of estoppel between landlord and tenant is subject. Firstly, a tenant is not precluded from denying the derivative title of persons claiming through the landlord. Secondly, estoppel is restricted to the denial of title at the commencement of tenancy. That is, it is open to the tenant even without surrendering possession to show that since the date of tenancy, the title of landlord came to an end or he was evicted by a paramount title.
This is precisely what we are saying. This is precisely what we are saying also. Even during continuance of your jural relationship, you can say that subsequently he has lost.
Yes, my lord, it is like this. My lord, I induct a tenant. I sell the property to my learned friend.
Exactly. That is one of
And
the
my lord,
situations.
then I go and file a
File
suit
an
that you
efficient
are
suit.
not paying rent.
I can
So
say
my
that
lord, the defense can be, I am denying your title because instead of X, Y has come in.
although our jural relationship still continues,
Correct.
but still I may say that subsequently you have
Correct,
lost.
correct.
That is what we are saying only.
Because my lord, the estoppel will be because over here, my lord, again, my lord, the distinguishing feature is this. My lord, I go back to the my lord, parent principle of estoppel. Representation, acting on the representation, alter your position to the contrary. The representation that which I had made.
We'll just join issue with you on a little aspect. If parent estoppel was sufficient, then 116 would not be carved out into the statute. We are just proposed. This is the proposition. You have to
My
distinguish.
lord, I will
115 would be sufficient.
I will put it in this way. 116 is, my lord, in fact, if
A species,
116 would not have been there, my lord, taking a
115 would be sufficient.
115 would
So
have
then
been
why was
sufficient.
116
But
put in?
the fact that 116 has come in, and that is why, my lord, I cited all the previous decisions that, my lord, during the continuance of tenancy has been held to be to continue till such time you hand back possession
Yes.
or you are dispossessed by a paramount title holder.
Yes.
And dispossession, it's not de jure, it also has to be de facto.
Yes, Mr. Chaudhary, 108Q operates vis-a-vis the subtenant whom we are speaking about, who is trying to dispute the title, and the his landlord. So his landlord, we are saying we are trying to explore when this jural relationship between this my landlord and the subtenant goes. So on that, one proposition is that when my landlord, the intermediate landlord, he or she, they put in, they surrender, or 108Q is complied by them. So then their title ends. We can say that their title has ended. And the other aspect is, I also under 108Q have to surrender my possession for my jural relationship to conclude. So regarding my jural relationship concluding, suppose if there is no 108Q on my part, I don't surrender. The relationship continues. But I say that my landlord's title has gone because of eviction decree or whatever. So the question is twofold. Not regarding, suppose if I don't surrender possession, then undoubtedly all these judgments you have cited are true. Then I cannot take advantage of saying that the jural relation. So then what happens? My relationship subsists. But still, whether I can say that my landlord's relationship title has gone.
Correct.
By virtue of that is, there are two components. We cannot mix up the two.
Well, Millard, in fact,
In certain judgments, both have been dealt with.
yes, but 108P obligation covers both cases of tenancy under rent control statute as well as transfer of property act.
What?
The principles.
What principle applies? 108Q is you have to immediately surrender possession.
100 and
The rent
Q is
control
if
will
it
have a protection. You
if
don't
the
surrender.
contractual tenancy ends, wherever it's a case of contractual
Mr.
tenancy.
Chaudhary, sorry, we can't agree with her. Correct us if
Yes.
you are wrong. 108Q says immediately upon determination, it's
Of
the
the lease.
obligation. It's the obligation of the
Correct,
lessee to
correct.
hand over possession.
Correct.
That is precisely against which protection is given in the rent control law.
I am
It's
not joining issue.
not universally.
I am not joining issue. I stand correct. This is under Transfer of Property Act 108 principles.
There is no doubt on that. Yes.
Will it kindly come to page 61 of Vasudev?
Yes. We are continuing.
The court stated that the rule of estoppel and set out the well-settled exceptions to which the general rule of estoppel between the landlord and tenant is subject. Firstly, a tenant is not precluded from denying the derivative title of the persons claiming through the landlord. Secondly, estoppel is restricted to the denial of title at the commencement of tenancy. Well, at the commencement of tenancy, well, this expression has come in because of the statute, which is being paraphrased.
Exactly.
But it has been clarified.
That is only the sticking point.
That is, it is open to the tenant, even without surrendering possession, to show that since the date of tenancy, the title of the landlord came to an end. Well, it is not the case here, or that he was evicted by a paramount title holder. Not the case here, or that even though there was no actual eviction or dispossession, under a threat of eviction, he had returned that to the paramount title holder. Well, this case also is not there. That is why I showed that there was no threat of eviction. He was trying to take a direct relationship, which failed, and then he ultimately surrendered sometime around 2023. That there was threat of eviction, and as a result of such threat, the tenant returned to the real owner was opined to be sufficient to constitute eviction by title paramount. However, this court has emphatically stated that if the tenant gives up possession voluntarily to the title holder, he cannot claim benefit of this rule. Well, my learned friend's client's case is he voluntarily gave it up. He has surrendered it sometime in 2023 or 2024. Neither pursuant to the decree then, nor pursuant to execution proceeding.
He surrendered possession.
Yes.
He sought a direct tenancy under the paramount.
He sought a direct tenancy.
He did not
Then,
surrender.
after this decree of eviction, and this was passed in 2014, he
Yes.
files the appeal, and then, mean profit is getting triggered, because formally, he does not surrender to me. Till date, he has not surrendered. So it is getting triggered, his liability. So what he does is, he goes and directly surrenders.
All right.
The judgment of this court in D. Satyanarayan's case, this is the distinguishing part. The judgment of this court in D. Satyanarayan's case has to be read as laying down that in the facts of that case, that the plea of tenant, that is landlord's title, had come to an end, did not amount to denial or claim which was not bona fide so as to attract applicability of clause 6 subsection 2 of section 10 of so and so. The common law rule of estoppel, as codified in section 116 of Evidence Act, that is why I am submitting, even if 116 would not have been there, 115 and the common law would have same consequences.
Without the commencement, then it would not be restricted to commencement.
I just read this line. The common law rule of estoppel as codified under 116 of Evidence Act and its exceptions have been dealt with for determining the core issue, whether the tenant denying title of landlord could be said to have done so bona fide or not. In D. Satyanarayan's case, nowhere has this court examined whether the relationship between the alleged paramount title holder and the landlord was governed by rent control law or not.
Yes.
Nor the question of obligation of the tenant to hand over possession to his landlord under section 108 of the Transfer of Property Act came up for consideration. These are features which distinguishes D. Satyanarayan's case before us. In the case before us, the plea of eviction by paramount title is not available to the appellant for 3 reasons. Firstly, it cannot be said that the trust is armed with a legal process for eviction which cannot be lawfully resisted by the respondent tenant, to which he has no defense. Secondly, the atonement by the appellant in favor of the trust is voluntary. and not under any compulsion. And thirdly, it cannot be said that the trust has such good and present title against the respondent tenant so as to hold the appellant liable to be evicted against his will. As already stated, and even at the risk of repetition, it has to be emphasized that in view of the respondent tenant's relationship with the trust being one governed by the rent control, his title as tenant will not come to an end unless and until suit for eviction filed by the trust against the respondent is decreed.
So therefore, rent control law was taken as a distinguishing feature, Mr. Chaudhary. Here it's clearly stated previously that rent control law was not decided in D. Satyanaran.
Correct.
But here rent control law protection is given to him. That's why it is stated that unless and until suit for eviction is precisely what we are saying. Is decreed.
Milord,
Not in your case. Your case is
no,
not
no,
covered.
that is all right. Milord, I am either way, my lord, in my case, I have distinguished it factually.
Yes, yes.
But
Otherwise,
I am only making this, my lord, if lordship considers. That is why I cited the first judgment of Justice Lahoti, that even in a case of Transfer of Property Act, my lord, it is like this, my lord, today, under 100 and let us say under 111A, a lease comes to an end. My formal relationship I am a tenant at sufferance. Now I have a sublessee whose lease by my lord de jure, it also comes to an end. But my lord sublessee continues, or let us say I am continuing.
it will be easier for you to accept, Mr. Chaudhary, if you put yourself into the shoes of the sublessee and give the example as if you are the sublessee, and then you will understand.
Let us say I am continuing after 111A. I am continuing after 111A.
Yes.
I continue for 5 years.
Yes.
I continue for 5 years. Situation 1, without paying a single penny.
Yes.
Landlord does nothing. Then, my lord, he files a suit after 5 years. My lord, this occupation of mine, from, my lord, the severance of the relationship till filing of the suit, my lord, is a tenant at sufferance.
Yes.
Situation 2, my lord, 2 months, landlord accepts monthly rent, mistake or otherwise, whatever. He accepts monthly rent from me after expiry of 111A. Lord, it is by holding over?
No. If he does not specifically agree to holding over, by mistake, if he accepts it's not holding over, well settled, umpteen judge.
Very well. Then also tenant at sufferance remains?
Yes. Tenant at sufferance.
So, tenant of sufferance is not, my lord, a rank trespasser. And
No.
that is why, my lord, so far as Transfer of Property Act, even, my lord, the same principle, you have to still get a decree to get eviction. This is what I am trying to say. It is not only in case of a rent control legislation, you must get a decree.
Yes, you are right. That's a waivable right. I mean, you may not file a decree suit for eviction at all.
Correct.
And then no possession will be handed over. We understand that component of your argument. So a decree
It is,
actually
my lord, at
necessary.
the end of the day, these are two personal rights which are, my lord, being equated.
Right.
And estoppel also is coming into the field because of representation made by person to person. So, if, my lord, it does not really matter whether, my lord, on the principles of estoppel, my lord, whether actual dispossession is taking place or not. That is why, my lord, even that passage which has been quoted in Justice Sen's judgment, it recognizes.
Yes.
Symbolically, you can do it, no actual dispossession. Because Justice Ganguly distinguished it that they have not taken into consideration. It is taking into consideration.
Bengal Club, we have referred to a larger bench. There also, Justice M. Bhattacharya's division bench judgment, similar modus operandi, that he has not taken into consideration. But what was not taken into consideration was actually relevant. Anyway, let us forget that.
So, my lord, in my respectful submission, my lord, even on the principles of law,
a pattern emerges in judgments. Patterns of particular judges emerges when you get to see so many of these.
My lord, even on principles of law, my lord, it is whichever way lordship looks at it, it is not a case of dispossession by title paramount holder, because eviction decree was long back. The execution proceedings came.
We have an additional point there that it could not be. He was no longer legally armed also.
Yes.
Because that decree was
12 years had passed. 12 years had
and
passed.
2197
And he could not have surrendered, my lord, pursuant to, because till 2014 he had actually, it is not the case before the learned single judge that I have surrendered because of the decree. This is coming in only at the appellate stage, and they, my lord, lordship will get the date. My instructions are end of 23 or early 2024. Because in 2014 he tried to again, my lord, I showed that letter. That came up when the special referee proceeding. Those are my submissions.
Thank you, Mr.
My lord, impugned order, one paragraph I
Yes.
just show your lordship. Because, my lord, my learned friend was critical of that one paragraph. Kindly come to page 291, volume 2. Well, kindly bear in mind, when we did this matter before the learned single judge, well, they did not bring it out, nor we could have been aware that, well, so far as we are concerned, that the execution proceedings had been dismissed.
Hmm.
Let us see, my lord, whether it can stand independently or
The
not.
execution proceeding was dismissed. It was not dismissed. Order 21.
Order 21. I stand.
Execution proceeding still
Nothing, no further orders were passed.
That still remains.
That miss case, my lord, that was dismissed.
This case was for police help. 2197 is when there is resistance.
And 12 years have passed from the decree.
No, but the execution case, parent execution case in connection with which Order 2197 was filed, that must be subsisting.
But I don't think so.
That is very important, Mr. Chaudhary, because otherwise this argument will go. If the execution, parent execution case is still subsisting.
Kindly see what was there.
If that was dismissed for default, that's different. It's not marked as a
No,
miscellaneous case.
Yes, that was also dismissed. Well, I showed page 103, question
103
6.
is, yes. let us
Page
see.
103,
So
question
that's
6.
their admission. Where is the document is
Yes, yes, volume 1, page 103.
103 is their answer. 100,
But then, my lord, Lordship is right in a sense. I can't say there was there is a document.
no,
What is the present status of this execution proceeding that was dismissed in the year 2003? Kindly see.
Mr.
Miss
Chaudhary,
case
one-
123 was
One-
transferred.
One second, Mr. Chaudhary. Miss case 65 of 2003 after transfer, that was, let us be clear on this. The previous paragraph says that was a proceeding under Order 2197. That was an application for getting possession with police help. Order 2197. That was dismissed for default. There is nothing on record to show that the parent execution case was ever dismissed for default. So why do you say that
My construction is, my lord, answer to question 6 is the status of the execution proceedings. That was dismissed. And, my lord, no contrary document has been shown. It is still pending. And, my lord, in any event, my lord, court has not done anything after that.
No, there must have been a stay. Must have been a stay from this court.
But I don't think so. I don't think so. Stay from this court.
Stay of the execution case. There is no stay of execution.
No, no. My lord, what was, I can only indicate, my lord, but I can't get. My lord, my clients were, the court was willing to continue, my lord, if we had paid in terms of their market rates, my lord, the rates. And we had said that we will recover mean profit.
We understand they sabotaged it by,
Yes,
by
yes.
trying to.
They were trying to do it then, my lord, in 10 years their efforts fail, then they come and take this plea.
Yes, yes.
That is what.
that-
Because, my lord, the court has been very lenient so far as my clients are concerned, in the sense that they were waiting, because we had said that, look, this, in fact, there are letters where we have indicated the status of our suit, who is in application. That is why, my lord, they did not, the court did not entertain. But this is, yes.
Go beyond records.
Correct.
I'm keeping to strictly to
Correct. But I am not going beyond records, my lord.
Very.
Irrespective of the records will show, my lord, this
No, you are saying something. One paragraph they have criticized.
Yes,
and you are going to say
291, page 291.
something. Yes.
Kindly see, in fact, if I may read from the last sentence of page 290, now that, my lord, we have discussed the law. In Krishna Prasad Singh, the Patna High Court considered 116 of Evidence Act. Their lordships were of a view a tenant could not escape estoppel merely by stating his tenancy under landlord was terminated, either by delivery of possession or by landlord's own act in determining the tenancy and bringing the suit for ejectment. nor can a tenant escape by stating that he came to an arrangement with a new person and attorned to him. Neither of these by itself were enough. The estoppel disappeared. However, if the landlord's title was extinguished subsequent to the inception of tenancy, or if there was eviction by title paramount. In the instant case, title of the original plaintiff was not extinguished subsequent to the inception of the sublease. The notice of eviction issued by Lalita Saduka as per se was not on the extinguishment of the right of the original plaintiff. The original plaintiff did not accept the notice of eviction and did not act thereon. The original plaintiff was not evicted pursuant to the notice of eviction by a court of law. Well, this is recognizing actual eviction because earlier Ganesh trading has been referred to, because this was criticized on the ground that look, this is where the learned judge has misdirected himself. But with respect, it is not so. Ganesh trading de jure de facto. Now, I read it again. The original plaintiff was not evicted pursuant to notice of eviction by a court of law. The right of the plaintiff, therefore, was not extinguished merely by suffering the notice of eviction from Lalita Saduka. The original plaintiff was not evicted by title paramount. Kolkata Port Trust authorities also admittedly did not evict. There should be a full stop. The original plaintiff was not evicted by title paramount. Kolkata Port Trust authorities also.
There is a full stop.
Oh, I'm sorry.
Micro full stop.
Kolkata Port Trust authorities also did not evict any of the parties from the suit premises. The defendants did not attorn in favor of any other person consequent to the notice of eviction issued by Lalita Saduka to the original plaintiff or otherwise. This is now borne from record. When the judgment was made, my lord, perhaps it was not there, but subsequently in the proceedings before the special referee, they have not attorned. They were trying to negotiate something.
Now, one last question to Mr. Chaudhary before we
Yes.
part, because we want to clarify this, your take on this. Now, 116, coming back to that, what he cannot deny is that at the beginning of the tenancy, landlord had a title to such immovable property. You have been arguing on the tenancy at sufferance, tenant at sufferance, that concept. Now, tenant at sufferance, definitely, it's somewhere in between trespasser and. But if the subtenant says that he is no longer a licensee, a lessee, but a tenant at sufferance, doesn't that also tantamount to saying that I am denying the title as a, because the tenant at sufferance, can he grant a lease? A sublease, could he have granted a sublease?
Well, to put it more simplistically, 116 says at the time of subsistence of the tenancy or
That
the
is the yes.
contract. Well, two questions can arise. Does it mean that after expiry of the tenancy,
Whose tenancy? The parent tenancy.
parent tenancy,
The landlord's tenancy. Yes.
after expiry he can?
After expiry, whether he can.
If we formulate this question,
Yes.
well, the answer it has to be in the negative for two reasons. Number one, irrespective of 115 or general principles of estoppel, you are acting on the premise. I am talking of Transfer of Property Act, because rent control lordship has already dealt with. You have come into the possession, again that representation theory.
So therefore, after this expiry, he becomes a tenant at sufferance and cannot grant a sublease. We agree on that. If that be so, therefore, whether it can be said that the landlord still has title, quote unquote, under section 116.
It is not required so far as title is.
So therefore, denial of title may also mean, I being the subtenant may also say that landlord does not any longer has title as a lessee. He has become a tenant at sufferance. So that's a derogation of title. Therefore, that's also a dispute. I deny that title. It may also mean that the subtenant can say, after expiry of a lease of my landlord, I am the subtenant, the landlord's lease has expired. 118, all those A sets in, and 108Q also sets in. After that, cannot I say that you don't have title as a licensee, as a lessee, but you have become a tenant at sufferance?
No, my lord, who can say that? That is why, my lord, the subtenant cannot say that. The subtenant will say, because it makes the situation worse for him. you don't have title, I don't have title, but it is between you. I am surrendering 108 P. That P comes in.
Q, yes.
Please, IQ. Kindly take possession. I am giving the possession. But why I say the subtenant cannot say it? Because law obliges him under section 108. After the expiry of his, you go and return it. You don't have to look anything else. You first comply with that obligation. Because, my lord, if the law assumes that he perhaps can challenge it, then, my lord, it will be in direct conflict with that Q, clause Q. That instead of surrendering, he is
No, but then beginning of the tenancy is there in 116.
correct.
He
So-
cannot
so-
deny the title at the beginning of the tenancy.
Correct. He cannot.
Subsequent tenancy, why can't he? Subsequent derogation of that title or
No.
denigration of that
My
title,
lord,
why can't he?
let us say, my lord, the tenancy is subsisting.
That's a
And
given.
my lord, we are clear on that. He can challenge the title when that is, let's say the ownership changes.
Subsequent.
So it has to be only two principles. Principles of atonement. Atonement is coming in two stages.
We are confusing two. One is subtenant's jural relation ending.
My lord,
That can come with atonement.
I am atonement can be in two situations. During subsistence of the contract, the original owner sells it to somebody else and writes that, look, I am selling this house
Yes.
to X.
Yes.
From henceforth, you give your lease rentals to Y, to X. So atonement is taking place.
Or surrender.
No problem in understanding this. Atonement to paramount title holder has also now been recognized after all these judgments have been
Yes,
discussed. This is the second atonement. Atonement to paramount title holder has been recognized only to a very limited extent. Because, my lord, in all cases where the lessor tries to go and directly negotiate with sublessee, that has been deprecated and we have fraud on underlessee and all these stuffs are there. You can't directly negotiate. The only limited extent atonement to paramount title holder has been, my lord, recognized is that you are facing a threat of disposition immediately in execution, actual disposition in execution. And then in the execution, you go and say, well, don't evict me out. Here it is, I am agreeing to have a contract with you. So let us say, my lord, in this situation, if we try to extrapolate this, 2005 or 2006, they write that letter, they enter into a contract.
But Mr. Chaudhary, again, you are coming back to the second criterion, which is the end of the jural relationship between the tenant and the lessor and the sublessee. We are not on that. Suppose that is subsisting, that can come to an end, as you are saying, when there is an immediate threat of eviction. We are not saying about that.
Lord,
Let us
I am
suppose-
also not saying that the jural relationship has come to an end. In fact, my lord, in execution, my
suppose
lord,
it continues. It continues.
yes.
But
So,
still,
my lord, what they have done in law, it will create an interesting situation. Their liability to pay mean profit continues till date.
to whom? You.
To me. My lord, they cannot escape. It makes
Despite your lease having coming to an end under
correct.
118A.
Correct. Because, my lord, as I have demonstrated,
Inter
If-
you, yes.
because, my lord, this is a dangerous stand which they have taken. And, my lord, if I am right in the submission, the liability continues. Other problems may come when I put it into execution. We'll think of that. They cannot escape liability, my lord, by surrendering it to the port.
Hmm.
Because, my lord, even today, there has been non-compliance of 108Q.
Hmm.
Till date, my lord, they are not saying.
Mean profit is a different chapter.
No. My lord,
They are at risk of that.
Correct.
They may run a risk of that.
so, my lord, why? If, my lord, I am
They are saved from eviction by you.
whatever. But they have gone and surrendered it voluntarily to the port.
They have tried to. It's not
Whatever.
been
But
taken.
now port has got it.
As you said, port is very kind to you.
But what is my remedy vis-a-vis the port and all? That's a separate aspect. I am
chapter.
not disclosing it. if I can revive it, if at all, whatever.
Need not. Why
That
should-
is a different thing. But, my lord, legally, if there has been no compliance of 108Q, my lord, the liability to pay mean profit continues.
Yes, mean profit continues.
It is like, my lord, here port. Why port? They can sell it. Let us say he puts in a third party and goes away.
Maybe, yes.
There are cases that you put in a third party, you go away. Can you say that I have surrendered my tenancy? No. So vis-a-vis, my lord, landlord and tenant, till such time you voluntarily surrender it to me and you say this, you get it recorded in a court of law. That we shall see, my lord. Let us first.
And just you please later on hand over that 85 copy.
Yes, yes. my lord.
Thank you very much.
Lord.
Mr. Ghosh, any short reply? Reply.
My lord, just a clarification.
Yes.
Vis-a-vis, my lord, when can they deny my title? They can deny my title after atonement under only those two circumstances.
Yes, yes, that yes.
ঠিক আছে। Well, next week I'll give my reply.
Next week.
Next Wednesday.
No, we'll continue with this after recess also.
After recess.
Yes, after recess you can give it. Not by us. Even constructively. So we'll continue after recess, Mr. Ghosh.
Okay.
Thank you. কোন order record করতে হবে না? recess এর পর continue করব। বাকি এগুলো সব
My junior may be here, my lord. Kindly
Oh.
excuse my absence.
Oh, I'm sorry, Mr. Ghosh. Forgot. After recess you have appellate side. You
What I thought.
Sorry.
What I thought, my lord.
Right, very good. Heard in part. For reply by learned senior counsel appearing for the appellant, comma, let the matter be listed on August 12, 2026.
Dodge.
Thank you. Huh? Right, meeting. Sorry. Accordingly, FAT 262 of 2026 is dismissed on contest, thereby affirming the impugned judgment and degree passed by such and such. However, in view of the pendency of the appeal till date, we hereby extend the time for the defendant appellant to quit, vacate, and deliver up vacant possession for a further period of 3 months from this date. In default, the plaintiff respondent shall be at liberty to put the decree into execution if execution has not already been levied. In the alternative, to proceed with the execution case after the expiry of the said 3 months period. Make it clear that other portion of the impugned judgment regarding mean profits is not interfered. Interim order, if any, stands vacated, no orders to cause. So you get your stay automatically. Yes. 3 মাসের সময় দিয়ে দিয়েছেন সারাদিন যাতে অ্যাপিলটা করতে পারে। বুঝতে চাইতে যাচ্ছিল তারপর শুনলে 3 মাস ওই জন্য সেটাই বলেন যে তুমি গেট ইউর স্টে। Yes, but thank you. Specially fixed.
My lord, this is my appeal.
Oh, acha, 3:2 years. For withdrawal?
Yes. My lord, may I just indicate why I'm seeking a withdrawal?
Yes.
My lord, in an eviction suit, my lord, where I have not been made a party, my lord, I have been evicted. My lord, first the eviction decree was passed. My lord, I had approached your lordships with this appeal. My lord, only the memo was filed. My lord, this was not admitted. My lord, in the meantime, my lord, the execution proceedings had been initiated. Now the decree has been put into execution. I have been dispossessed. So, my lord, right now, my lord, the right step that I should be taking, my lord, I should be approaching the executing court. My lord, without taking the leave to appeal, my lord, this appeal had been filed, my lord, I believe on wrong advice. My lord, may I, in this background, seek a withdrawal of this appeal and, my lord, with liberty to approach the executing court with the right application, my lord.
If otherwise you have the remedy available in law.
Yes,
We'll put that in order.
yes.
Learned counsel for the appellants, on instructions, submits that the appellants seek to withdraw the appeal with liberty to approach the executing court for appropriate relief. Full stop. Accordingly, FAT 372 of 2023 is dismissed as withdrawn with liberty to the appellants to approach the executing court for an appropriate remedy, if available otherwise to the appellants in law. No orders to cause, urgent certified copies. Leave is granted to the appellants. The leave is granted to the learned advocate and record for the appellants to take back the certified copy of the impugned judgment upon furnishing photocopies there.
I'm so grateful.
Thanks.
Item number 4.
Yes, that.
I appear for the petitioner.
Yes, we are observing, Mr. Banerjee, that the learned single judge passed that order apparently without taking note of the fact that the appeal was preferred against an order passed in a miscellaneous appeal under the erroneous impression that it was from the suit and
Malad, only prayer is that
conversion you are asking.
Yes, conversion. The
Yes,
other
we are converting
I
it.
don't think, Malad,
If they have no difficulty, we have no difficulty. We thought that 227 would be easier for you because otherwise the memo does not, the stay application has to be treated as whatever. Anyway, very well, we'll put something in our order. A peculiar predicament has, what is that order?
my lordship can give that liberty to amend, which usually is given, my lord, in the department.
Amend what? That is what we are asking.
Malad, I think, my lord, the
This can be renumbered.
renumbered
but
and
then-
my lord, cause title, my lord, the opening parts are, my lord, changed. It happens. We have, my lord.
Yes, it happens. But Mr. Banerjee, we have faced difficulty there because the nature of the averments here.
If it is there in the order, my lord, then I
See,
don't.
paragraph 15. You say being dissatisfied, you have preferred an appeal. And then you say so many other things. So we cannot grant you liberty without a supplemented affidavit. You cannot amend those because it has been signed by your
Let
client.
there be a supplementary affidavit, my lord, leave be granted. We'll do that, my lord. We'll do that because, my lord, it is only cosmetic, my lord, nothing more than that. The law, my lord, is
No,
very
it's
simple. It's
cosmetic.
already pleaded. It would be only cosmetic to have a supplementary
Very well,
affidavit.
no difficulty. And we'll just look at that order of the learned single judge. You had handed over.
109, my lord.
190.
90. The
Yeah.
last check.
And order is 107.
You have challenged the refusal of an injunction or?
extension of interim order and
extension of interim order, and they had filed an application under section
39
34.
4. Right. No, learned single judge's order, where is that? We are
119, my lord.
Yes. A peculiar predicament has arisen before this court. First of the present appeal has been preferred against an order refusing to grant injunction and allowing an application for vacating the ad interim injunction earlier granted under Order 39, Rule 4 of the Code of Civil Procedure, comma, passed in a miscellaneous appeal, comma, which was filed in the first place against an order under Order 39, Rules 1 and 2 of the Code of Civil Procedure. Full stop, next para, as well settled, comma, no further appeal lies against an order passed in a miscellaneous appeal under Order 43 of the Code of Civil Procedure. Full stop, next para, however, comma, video order dated April 10, 2026, passed in CO number 996, 996 of 2026, comma, which was initially preferred under Article 227 of the Constitution against the self-same impugned order, comma, a learned single judge was pleased to observe that the revisional application was not maintainable, comma, having been preferred against an order under Order 39, Rules 1 and 2 of the Code, and granted liberty to the petitioner to file an appropriate challenge. For sub next para, however, comma, it is evident from a perusal of the order that the learned single judge proceeded on the mistaken notion that the appeal had been preferred against an order passed in an original suit, and by overlooking the fact that the order was actually passed in a miscellaneous appeal, comma, against which no further appeal lies in law. Full stop, next para. Thus, comma, since, comma, as a chartered high court, comma, this court has ample power to rectify its errors, comma, if any, comma, we dismiss FMAT 152 of 2026 as not maintainable, comma, granting liberty, we dismiss the corona. We convert FMAT 152 of 2026 to, we direct FMAT 152 of 2026 to be converted to an application under Article 227 of the Constitution of India. Full stop, the office shall allot a new number, a CO number to the matter accordingly. Upon treating the averments made in the stay application bearing can 1 of 2026, comma, filed in connection with the miscellaneous appeal as the necessary pleadings of the proposed application under Article 227 of the Constitution of India, and the grounds taken in the memorandum of appeal as the grounds thereof. First up, liberty is granted to the appellant, comma, now petitioner, comma, to file an appropriate supplementary affidavit, comma, if any, comma, to introduce other consequential amendments to the pleadings made in the stay application and stroke out the memorandum of appeal before the learned single judge, having determination to take up the matter as a motion. Can 1 of 2026 stands no further order will be passed. Yes.
Only thing, my lord, I was saying that let this supplementary affidavit be treated as part of the pleadings of the 227, my lord.
No, we said that the supplementary affidavit to introduce the necessary whatever.
Very well. Very well.
This order will be sufficient if you
Yes,
place
yes,
it before
of course, of course. Grateful. my lord.
Thank you. একবার কল করুন, আমি বলে দিচ্ছি 26 আসার কথা। ও আচ্ছা, তাহলে কল করুন যদি this matter is appearing under a wrong heading, so although nobody is appearing, we are telling in open court that it will appear under the correct heading tomorrow. It is dispose of. Very well. This matter is appearing erroneously, although disposed of earlier. Full stop. Accordingly, let the matter go out of the list. It out of list করে দিলাম, যেটা কারেক্ট দয়া করে কালকে দিও সেটা। তাহলে এটা তো আগে ডাকতে হতো। কেন, কে বলেছে তোমাকে? এটা তো অন্য ম্যাটার। এটা বুঝতে পারছো না? এটা তো অন্য ম্যাটার। এটার সঙ্গে এটার কি সম্পর্ক? এখন কি করে ডাকবে স্পেশাল ফিক্স? ডাকো স্পেশাল। অদ্ভুত তোমরা কন্ডাক্ট করো কোর্ট। ডাকো। Yes, is the other side ready? Because this is under these peculiar circumstances. I mean, it's our fault. Wrong number.
Come at 10:30 and subsequently I have been informed that I have to mention at 2, but subsequently appearing at 2.
No. Yes,
Yeah, Bhattacharya
obviously.
is happy.
Yes, Mr. Bhattacharya is not there. That's what.
So can it be posted tomorrow, my lord?
Which matter?
This matter, but I'm not briefed, my lord.
Why are you rushing?
I am requested by the GP office to inform that Nilanjan Bhattacharya was appearing in the matter.
Yes.
And he is today at hospital because of his, almost in a admission stage because of his blood, some problem.
What?
Yes. Nilanjan Bhattacharya, he is
When
there.
should you keep it, Mr. Banerjee? We have granted limited protection to them till the end of this week.
No, 14th of March. 14th of August.
So tell us when we'll keep it. Not very close to 14.
Lordship,
Otherwise, if we'll keep it on another date, Mr. Banerjee. If you make alternative arrangements, it's fine. You will appear in the matter.
if he is there, he will appear. Lordship, interim order protection is passed today or early?
No, earlier, yesterday, on the Saturday.
It's on here.
No. Then today we are on today is 5th. So you have granted it till 14th.
14th.
So
We are
Lordship,
keeping it on 10th of August.
10th or 11th, Lordship.
10th of August, we are putting it for the time being. If there is any difficulty, we'll consider.
Yes.
An adjournment is sought on the ground of the ailment of learned senior stand-in counsel appearing for the state. So accordingly, let the matter stand adjourned till August 10, 2026, when it will be listed under the heading specially fixed matters. We are keeping it as specially fixed so that it's taken up earlier than the others.
I'm
Thank
ready.
you. Thank you.
Number 6 to 9.
Nobody is appearing for the state, but we have soft copy.
You have served a notice. We'll keep that on record and we'll proceed to hear it. What can be done?
14 years, the person custody.
Yes. Service has been effected.
No effective.
What is the charge, Mr. Bose?
10-2.
You don't appear below that level. 302 level.
No, I appeared on the earlier occasion.
Yes, obviously.
Other date is 6 March 2013.
Let us see when it was last rejected.
256.
256 of the paper.
No, 2013, the bail was rejected last on 2013. In 2013. After that, you have not paid for bail.
No.
The appeal is otherwise ready for hearing.
That's
14 years in custody.
14 years. More than 14 years.
The affidavit of service filed to be kept on record. Full stop. Despite service, none appears for the state. Full stop. Next para. We deem the service to be sufficient notice on the state through the public prosecutor and take up the application for suspension of sentence for adjudication. Full stop. Next para. Learned senior counsel for the petitioner points out that the petitioner is already in custody for about 14 years. Full stop. Next para. A similar prayer for suspension of sentence was last refused long back, on March 6th, 2013. Full stop. we are apprised that the appeal is otherwise ready for hearing. Full stop. However, comma, in view of the fact that the appeal has still not been disposed of, comma, we are of the opinion that the personal liberty of the appellant stroke petitioner is seriously curtailed, comma, keeping in view the long period of incarceration already suffered by the petitioner. Full stop. Next para, even otherwise, comma, since the trial is long over and the matter is pending at the appellate stage, comma, there is no scope of the appellant stroke petitioner tampering with evidence or influencing witnesses. Full stop. Accordingly, CRAN 3083 of 2013 was it pending for so long? Is this was this originally to the legal aid or what's 13 years is pending? Anyway, is allowed, comma, thereby granting bail to the petitioner on condition that the petitioner furnishes bond of rupees 10,000 with 2 sureties of like amount each, one of whom must be local, comma, to the satisfaction of
CGM Barasat 24 Parganas.
learned Chief Judicial Magistrate, Barasat, 24 Parganas. North. Full stop. Next para. Not 24 Parganas. Yes. Full stop. Next para. The appellant stroke petitioner shall not leave the territorial jurisdiction of his residential police station during pendency of the appeal, apart from making himself available as and when, if and when called to so appear in connection with the appeal by this court. Thank you. Arakta line add further. The liberty to the parties to mention the appeal for enlistment before the appropriate bench having determination, having regular determination. Thank you.
Item number 10.
10.
Lordship, I'm for the state. Lordship, I'm being led by Mr. Kaushik in this matter. I'm for the state. We have received the brief yesterday. We have been allotted the brief yesterday.
11 years in custody.
11.
11 years in
Similar as the
custody.
previous one. Same,
It
same.
was last rejected, my lord, in the year of 2019. 7 years of.
Someday. Next week.
My lord, it was,
No, not next week.
it was received by them on the 4th of August, my lord.
No, not next. Why next week?
Monday.
Why permit him to stay another night in jail? Why should you do that?
This is on Friday.
No, not Friday. Why Friday? Today is Wednesday. Tomorrow we'll take up. On whose ground are you asking for test?
Mr. Kaushik.
Mr. Kaushik is not in court.
We are not even ready with the matter. We have received
Oh, you
the brief yesterday.
What is there to be prepared in the matter? Suspension of sentence, 7 years in how many years in custody?
11 years in
11
custody.
years in custody.
And 7 years
That's
since the
it
last
for you.
rejection.
We'll record your opposition and do it. Allow it. No. You are also on the panel. Very well, we'll then allow it. The appellant is behind the bars for 11 years. First up, although the nature of the offense is heinous, comma, we find from the records that that a similar application for suspension of sentence was last refused as long back as on May 11, 2018. Full stop. Next para, keeping in view the taking into consideration the personal liberty of the appellant, comma, which is being severely hampered due to long pendency of the appeal, and the substantial period already spent by the appellant behind the bars, comma, we are inclined to grant the benefit of suspension of sentence stroke bail to the appellant. Full stop. Accordingly, CRAN 3 of 2026 is allowed, thereby granting bail to the appellant. Similar conditions to the satisfaction of whom?
Krishnanagar.
Chief Judicial or ACJM?
I'm a CGM.
CJM Krishnanagar. CJM Krishnanagar. District Nodia.
And my lord, the date of the last rejection, my lord, that is the 25th of January 2019.
আচ্ছা ওই ডেটটা যেটা 18 বললাম 25th
of January 2019.
January 25, 2019.
Deeply obliged.
Thank you. একটা লাইন অ্যাড করে দেবেন। At the outset, comma, learned counsel appearing for the state seriously, or what should be the adjective? Vehemently opposes the prayer for bail in view of the gravity of the offense. তারপর বাকিটা যাবে। Yes.
Item number 11.
Yes. বাকিগুলো সব তাই বললাম, আগেরটা যাব তাই সেটাই বললাম, বাকিটা আগেরটার মতো 10,000 ইএফএ সব এক্স্যাক্টলি আগেরটা যা হলো তাই। Sorry, 11, yes.
Lordship, item number 11, I am for the.
You're for the
petition.
state. Why are you here? Bring the
I am
petition.
for the appellant in this matter, Lordship.
This is an appeal.
Yes, my lord, appeal from.
You move the appeal for them and then controvert also what they have to say.
My lord, can you
Fixed on their mentioning and they're not appealing.
I'm for the,
Very
I'm
clear.
for the appellant, Lordship.
দেখি এটা কি আগের দিনও নিয়েছি, কোনোদিন আগে নিয়েছি এর মধ্যে?
Lordship, I am for the
আজকে ফার্স্ট,
petitioner in this
আজকে
matter.
ফার্স্ট এসে you are giving them a chance, one chance. Although the matter is appearing upon being mentioned by the appellant, comma, none appears for the appellant at the time of call. Although the state is represented through counsel. Full stop.
Lordship, I am for the petitioner
As a
in
last
this
chance
matter.
to the appellant to move the matter, the same is adjourned for the day.
I'm for the petitioner in this matter, Lordship.
I have some.
After 10th,
I'm for the
the
petitioner.
regular
in
bench will return then. Our determination কবে পর্যন্ত আছে আমাদের? হ্যাঁ 10 পর্যন্ত। You want it to be heard before the regular bench?
If it is tomorrow, then.
No, if you want, we don't have any difficulty because you have your say now. They are not happy.
Then.
Tomorrow. Adjourn for the day. Let us see if they don't come tomorrow. Then
Grateful.
Item number 12.
Well, my lord, I am for the appellant, my lord.
I'm for the state.
yes, in a new avatar. Yes. What is the matter, Mr. Mitra?
This is, my lord, the person has been asked
Yes.
to deposit an amount for excess overdrawn amount in the verge of his retirement. And
What is this? This is an education matter.
yes, my lord.
Group 2, yes.
My lord,
Verge of retirement, excess payment or
excess payment overdrawn as an
what is the law on that, Mr. Mitra?
Well, Mr. My lord, I have asked
You can cite any latest judgment
Yes,
because
yes,
we are out
Rafiq-
of touch with this.
Rafiq Musi's judgment says, my lord, before 1 year of retirement, even if it is paid wrongly or the calculation is, my lord, miscalculation is done by the state, if it is been paid and it has been recovered, it cannot be done within 1 year of retirement.
After that, it can be done.
No, after it at all done, it was before that Abdul Qadir's judgment in 2016.
No,
I
if
have
they
the
want,
judgment.
if they want recovery, they have to do it within 1 year.
Before 5 years.
Before?
5 years. I'm placing the judgment.
No. When did you retire?
I retired in 2022.
So according to you, according to the law laid down, what
Yes,
does the law say?
yes.
Have you got a copy of the judgment?
Yes.
Just look into that.
Hmm.
Mr. Rai, do you object to that proposition of law that this is the last position?
Yes.
Fair, let him argue, then we'll come back to
Para 18. May I read one or your lordship? Considering all the earlier judgments, para 18, my lord, it postulates when recovery cannot be done.
This is class 3 and 4.
No, my lord, the class 3 and 4, petitioner is, my lord, is a teacher. Para 2, Roman 2, Roman 3, and Roman 4, I am. Here, recovery, my lord, took place. 7 months before the retire.
So you come within, you come within that bracket,
Yes.
within 1 year.
Yes.
2.
And also Roman 3, recovery of the employees when excess amount has been made for a period of excess of 5 years.
How long was this excess payment made?
Excess of payment has been made from 1989 to 2001.
1989 to 2001?
Yes, page 37, my lord, of the stay petition.
And 4 is recovering cases where has wrongfully
That is not, my lord, my case.
not applicable.
Roman 2 and Roman 3, my lord.
Yes, what do you say, Mr.?
My lord, kindly come to their own petition, my lord, para 8. I've got, I'm not posted to the read petition, but my lord, kindly come to
Right.
the application for modification they have filed. That is application for modification of the order passed by the Christina, para 8. What is the period? The petitioner came to know from the office of the respondent number 5 that an amount of rupees 85,000 so and so has been overdrawn in respect of HAR during the period. This is during the period from 1999 to 2010. But kindly come to page 37. This speaks of period from 1989 to January 2000.
2001.
So
We'll ignore this abandonment. This abandonment is wrong, but still it remains page, which page? 30?
37.
So
37. Still it remains what Mr. Mitra submitted.
but they have deposited.
1998.
Yes.
89 to January
No, 89.
2001.
March 89 to January 2001. As it
2001.
said.
That says 1999 to 2010.
Wrong abandonment in the petition. We'll ignore the petition. We'll rely on your document. This document.
Another thing, my lord, she has already deposited. Now she is challenging.
Yes.
She has
Yes.
Deposit under compulsion, under duress.
Yes.
But my lord, she has not promptly challenged after 3 years.
This challenge is,
No.
the writ petition was filed after 3 years.
No, within 3 years. That is the point taken by the single bench. That was not true. Kindly have a look. My lord, the
3 years, 137 was applied.
no, it's not applied. My lord, it's taken within a reasonable time. Reasonable time in the writ petition, reasonable time. It is entirely upon your lordship. My lord, considering the facts.
What was the
and
ground you cited in your writ petition
My
for the
lord,
delay?
My lord, I know within 3 years. I cannot want to explain. Kindly have a look. Well, page 37, it is 30th December 2021.
Actually, my lord, I have no knowledge when the writ petition was.
No, it was 24 writ petition.
filed.
Who can say number to 24
No, 2024, that much you know. Writ petitions are not renumbered.
Order passed on 20th of February 26.
That's all right.
Order pass date is irrelevant. 30th of December 2021, this.
One. And the next page, your lordship kindly keep the pension payment order issued on the top right hand side of 14 July 2022. I am well within, my lord.
Whether any.
But it was not appraised
So it was
properly.
within the period of a money suit. So it's a money claim basically.
But in the, I don't know whether in the writ petition there is explanation after retirement she is filing this.
Within 2 years, I have filed the writ petition as a retired employee, my lord.
Retired
No,
employee.
it was deducted from your retirement benefits or
Yes,
you paid
yes.
it.
Yeah, I paid it because unless it was not paid, PPO has not been issued.
It was paid when she was in
After
service.
payment only,
What was the quantum, Mr.
85,000.
5,000. She paid when she was in service. No protest, nothing. She has not challenged.
Your fault.
But-
You are not
but-
debarred, but
then she has to satisfy. that
no, this Supreme Court judgment applies. We are bound by this
My
judgment.
lord, I say, my lord, learned single judge is passing the similar orders. Where a learned single judge was not appraised properly, that I am well within 3 years.
My lord, there is another.
Kindly have a look the single bench order also, my lord.
No, that you have annexed here.
No, my lord, similar orders has been passed.
No, obviously, yes.
Considering Rafiq Musi, it is the usual order.
Why
of the
didn't you
court.
take out a review application before the
My lord,
licensing?
it was not done, my lord. My lord,
That would have been an easier remedy for you.
yes, my lord, that's true, my lord. It has not been appraised properly.
Particularly since the learned judge is passing similar orders, you are saying.
Yes. And in
You have just-
2025, I also relied on the judgment. Well, a similar order, same
that-
ratio.
Yes.
But the Supreme Court said, my lord, subject to correction, my lord, unless there is a fraud or
Yes,
misrepresentation.
here, my lord, no fraud, my lord. It was detected in the verge of the retirement. That 12 years.
Supreme Court judgment creates a bar to recovery of that amount after this
There is
period.
another judgment, my lord, 2012 8 SCC page 417.
Please cite it, yes.
Now, kindly see para 14. In the absence of any, in the
What are they?
absence-
This
You choose the judge and the other one will pass the order. Yes.
in the absence of any fraud and
Yes.
misrepresentation, my lord, taxpayers' money. She has admitted, she deposited. We are concerned with the excess amount payment of public money which is often described as taxpayers' money, which belongs neither to the officers who have effected overpayment nor to the resident.
Officers commit the error and obviously it's not their money.
She admitted.
Which paragraph of this, Mr.
Para
Rai?
14. Para 14. She has paid she understood. She has
Who
not
understood?
challenged the order that why I am compelled to pay. She has accepted this. Thereafter, after making payment after more nearly 2.5 years, he is saying that this is wrong. And the payment was made when she was in service. Any amount paid received without the authority of law can always be recovered, barring few exceptions of extreme hardship, but not as a matter of right. In such situation, law
This was taken into consideration in the subsequent judgment.
consideration, but some parameters are there. But my lord, it is my
This was taken into consideration by subsequent judgment.
it was
That is what we
sufficient before
looked
the
at.
lordship that she understood that she has made the moment she paid, she could not have paid. She could have raised the dispute that why I shall pay. After making payment, this is the point, my lord. This is my submission before your lordship. Kindly decide the matter. Had it been a case that she has not paid,
But kindly note, my lord, I am not asking for refixation, only the amount. I cannot entitle to get the refixation. It may be done rightly, may be done wrongly.
amount, my lord, whether this can be recovered by filing a writ petition, my lord.
We are deciding the appeal itself. No need. I mean, if you stay the order, there no useful purpose will serve.
As well.
Since a short point is involved, comma, we take up the appeal itself for hearing along with the connected application. So the next para. By the impugned order, comma, the learned single judge has dismissed a writ petition filed by the petitioner, comma, a retired employee, comma, where the writ petitioner sought a refund of the excess amount of excess payment allegedly made to her by the respondent stroke employers. Puts up next para. While dismissing the writ petition, comma, the learned single judge observed that the employer has the right to rectify the error in pay fixation of the employee well within the service tenure, and once order for refund of the overdrawn amount is accepted and refunded without any objection, then the same ought not to be permitted to be challenged in a subsequent proceeding. Push-up, the learned single judge further observed that the writ petition had been filed by the petitioner more than 3 years after depositing the amount found to be drawn in excess, and as such the same cannot be allowed. Push-up, next para, learned counsel appearing for the writ petitioner stroke appellant argues, comma, by placing reliance on such and such reported at 2012-8 SCC 417 that ভুল বললাম, reported at 2015-4 SCC 334 that in terms of the parameters laid down in paragraph number 18 thereof, comma, recovery from retired employees or employees who are due to retire within 1 year of the order of recovery, and recovery from employees, comma, when the excess payment has been made for a period in excess of 5 years, comma, before the order of recovery is issued, comma, is impermissible. Push up, in the present case, comma, it is submitted that the recovery was done about 7 months from the date of retirement. Push up, next para, moreover, comma, the period for which excess payment was sought to be recovered was much in excess of 5 years, comma, being between the years 1989 and 2001. Push up, next para, learned counsel further submits that the petitioner was compelled to pay the amount in view of and under the threat that the pension order would not be signed unless she refunded such amount. Push up, as such, comma, such payment of the amount cannot be construed to be an acquiescence on the against the acquiescence on the part of the petitioner in respect of her right to challenge the same. Push up, next para, learned counsel appearing for the state seriously opposes the appeal and cites such and such reported at 2012-8 SCC 417, where it was observed by the Honorable Supreme Court that it failed to see why the concept of fraud or misrepresentation is brought in such situations where excess payment of public money, comma, which is often described as double inverted taxpayers' money, double inverted clause, comma, which belongs neither to the officers who have effected overpayment nor to the recipients has been made. Full stop. Next para, the Honorable Supreme Court further observed that the question to be asked is whether excess money has been paid or not, comma, which may be due to a bona fide mistake. Full stop. Next para, it is also contended by learned counsel for the state that the Honorable Supreme Court further observed that any amount paid stroke received without the authority of law can always be recovered, barring few exceptions of extreme hardships, but not as a matter of right, comma, in such situations, law implies an obligation on the payee to repay the money, comma, otherwise it would amount to unjust enrichment. Push up thus, comma, it is submitted that the writ petitioner stroke appellant, comma, having once paid the amount, comma, preferred the challenge much thereafter, and as such, comma, the learned single judge was justified in dismissing the writ petition. For sub next para, upon hearing learned counsel for the parties, comma, we find that even in Chondi Prasad Unial, UNIYAL, Supra, comma, the Honorable Supreme Court observed that there are few exceptions, comma, including extreme hardships, comma, which carve out an exemption from the general principle that an amount paid stroke received without the authority of law can always be recovered. Full stop. Next para, the said judgment was considered, comma, along with other judgments then governing the field in the subsequent judgment of Rafiq Masi, RAFIQ, space MASIH, Supra. Full stop. In paragraph number 18 thereof, comma, the Honorable Supreme Court categorically carved out certain exceptions to the rule of recovery of excess payment. Full stop. As per the said paragraph, comma, it is not possible to postulate all situations of hardship which would govern employees on the issue of recovery, comma, where payments have mistakenly been made by the employer in excess of their entitlement. Full stop. Be that as it may, comma, the Honorable Supreme Court observed, comma, based on the decisions referred to in the said decision, comma, as a ready reference, comma, certain situations were summarized wherein recoveries by the employers would be impermissible in law. Full stop. Two of such situations, comma, where recovery is impermissible to quote unquote, comma, as laid down in paragraph number 18 of Rafiq Masi Supra, comma, are as follows, colon, niche small a within bracket, recovery from the retired employees, comma, or the employees who are due to retire within 1 year, comma, of the order of recovery, semicolon, space and niche small b within bracket, recovery from the employees, comma, when the excess payment has been made for a period in excess of 5 years, comma, before the order of recovery is issued. For sub next para, in the present case, comma, both the aforesaid criteria are met, MET. For sub next para, the recovery was effected about 7 months prior to the retirement of the petitioner, comma, thus coming within the first above mentioned clause, comma, restricting such recovery within 1 year from the date of retirement, full stop. Next para. Moreover, comma, the period for which excess payment was recovered was much more than 5 years, comma, being from the year 1989 to 2001. Full stop. Next para. Insofar as the payment having been already made by the writ petitioner stroke appellant is concerned, comma, it is evident that under the threat of withholding of her pensionary benefits, comma, the petitioner was obligated under compulsion to make such payment. Full stop. Although no specific objection might have been raised by the appellant at the relevant point of time, comma, mere non-mentioning of such specific objection does not curtail or take away the legal stroke constitutional right of the of an employee to assail an illegal recovery, comma, in the teeth of the proposition laid down in Rafiq Masi Supra. Full stop. Next para. Moreover, comma, insofar as delay is concerned, comma, the writ petition, comma, comma, was filed within the period of 3 years. Full stop. Although no limitation period is applicable to a constitutional remedy under Articles 226 or 227 of the Constitution, comma, by even borrowing from the principles incorporated in the Limitation Act, comma, the uh, limitation period for a money claim is 3 years, comma, within which the present writ petition was filed. Full stop. Next para. Thus, comma, we do not find any undue delay on the part of the writ petitioner stroke appellant in preferring the challenge. Full stop. Hence, comma, this court is of the opinion that the petitioner, the appellant was entitled to a refund of the amount recovered from her uh, by way of excess payments in view of the appellant coming within the ambit of the exceptions as enumerated in Rafiq Masi Supra. Full stop. Next para. Accordingly, MAT 614 of 2026 is allowed on contest, comma, thereby setting aside the impugned judgment and order dated February 20, 2026, passed in WPA 17564 of 2024, and directing the respondent authorities to refund the excess payment deposited by the petitioner, comma, to the tune of rupees 85,000. 85,000, full stop. However, comma,
85,105.
85,105 oblique dash, full stop. However, comma, since the petitioner herself deposited the amount, comma, we abstain from imposing an interest thereon. Full stop. Next para. Consequently, no.
Why I'm saying, my lord, this will, my lord, only
You yourself deposited the amount.
My lord,
Otherwise, you would have imposed it.
my lord, I deposited the amount, but this has
They are
been,
not at fault. You deposited with them.
my lord, our bench is passing orders, my lord. Kindly, my lord,
No, no,
not
this
to-
bench will not pass.
No, then you
You
lord,
have given the reason also.
then my lord, kindly not. I am not pressing interest that because it will be
Very
go to the
we
other.
understand. We understand. Last line ta interesting. একটা জিনিস বলে দাও। At this juncture, comma, learned counsel for the appellant does not press for interest on the amount, full stop. As such, comma, we do not adjudicate upon the entitlement of the appellant to get interest.
Great.
Full stop. However, comma, we also make it clear that this component of our order shall not be a precedent and is passed on the basis of the facts of the present case.
Great.
Full stop. Consequentially, can 1 of 2026 stands disposed of as well, no orders to cause, urgent certified copies. প্রথমে affidavit of service filed to be kept on record.
For the can one, since my lord, your lordship has recorded that he was compelled to pay the money. So allegations are not.
Oh, আচ্ছা। What allegations? আচ্ছা, very well.
Recorded.
একটা লাইন অ্যাড করে যা বললাম সবকিছু পরে, since we have not invited any affidavits in respect of can 1 of 2026, comma, it is deemed that none of the allegations made therein are admitted by the respondents.
There are so many, my lord.
Understood.
That is why I have,
Yes, we know you have a cottage industry on this.
because there are orders, because where the adjudication of the grant asking for relief by the DI jurisdiction has been, my lord,
You
division bench order.
take copies of this judgment when you go to sleep also. They're in your head in any event.
Grateful.
Thank you. Yes. কত এটা? 13। 2013 রেজিস্ট্রেশন করতে কে এলো এটা? এত ওল্ড ম্যাটারে যায়নি কেন? দেখি রিসেন্টলি রেজিস্টার করেছে। তো ওল্ড ম্যাটারে নেই কেন? মেনশন করেছিল? ও। Although the matter has been enlisted upon being mentioned by the appellant stroke petitioner, comma, none appears to move the application at the time of call. Full stop. As a last chance to the petitioner to move the matter, the same is adjourned for the day. Next. Registration. Yes.
Reply to
With cost of 1 rupee, Mr. Right?
this was Millard dismissed for default Millard before admission of the second appeal.
Non-appeal.
With section 5.
Restoration.
Restoration with section 5.
Yes. Yes.
So what is the
order of
date?
party of stage? It will be heard by this division bench, my lord, having determination.
You come prepared on the order 40 and we'll take up the order 40 on consent of parties. You are ready now?
Restoration will
6 years, my lord.
So if you can dismiss it right now, why should you? No, let us try to dismiss it. Why the delay?
only explanation is lawyer's fault and thereafter COVID.
You are the lawyer. Give a notice. You are the lawyer.
Sandeep Kumar Tiwari.
So give Sandeep Kumar Tiwari a notice. You can bring him. If you can bring him, we will pass an order. Bring him. Bring Mr. Tiwari. Bring Mr. Tiwari or we will direct you to serve a notice.
He's there.
No, he is there. Sandeep Kumar Tiwari we want. Bring him. Pass over. Pass over. Yes, let him admit his fault. Why, Mr. Bhattacharya? Why don't you just keep the previous advocate on record and move it? Client's choice. Very well. Yes.
File for the affidavit of opposition.
Yes. This is item for 15.
15.
Yeah.
May please, your lordship, I am appearing for the
Yes, Mr. Adhikari, what is the matter? What is this opposition?
Opposition, my lord.
This is my affidavit in reply.
Achha.
Last day, my
The-
lord, I am not.
You have not got a copy of the reply?
Huh?
Not got a copy of the reply?
Yes, my lord, he received.
Got a copy.
But why are you spreading your hand?
Mentioning before your lordship, last day,
Yes.
I am not served for the opposition. I
Yes.
for the opposition 15/7/2026.
This was a wrong submission.
Hmm.
So, Adhikari, you submitted that it was no opposition was served. We have recorded on the last date. How can you prepare a reply then? Unless
My lord, yesterday my learned junior friend has not come, therefore I could not, my lord, follow this.
at the outset, it is pointed out by learned counsel for the respondents that an erroneous submission was made on behalf of the appellants, as recorded in the order dated August 4, 2026, to the effect that no copy of any affidavit in opposition has been served on the appellants, whereas the same was served some time back. Such contention is substantiated by the fact that the appellants are ready with their affidavit in reply to the affidavit in opposition, which could not have been in the event no copy was served previously. Accordingly, we take note of the fact that the affidavit in opposition was actually served on the appellants much prior, contrary to what has been recorded in paragraph number 2 of the order dated August 4, 2026. The affidavits in opposition and reply filed to be kept on record. What is Can 4? What is the matter?
Can 4 is the, my lord, violation of the order passed by the Honorable Court in the, my lord, after admission of the appeal. My lord, kindly come to the, my lord, my prayer. This, my lord, appellant petitioner paid for the mandatory injunction for demolition of the structure during the pendency of the injunction granted by this Honorable Appellate Court. My lord, kindly see that Annexer A, page 9, the appeal was admitted, and my lord, Can 1, the injunction application, and in that application, lordships were pleased to pass the interim order of injunction maintaining status quo to be maintained by the parties as regards possession during the pendency of the appeal and not to change the nature and character of the suit property. My lord, in the meantime, in the month of October, my lord, the respondent number 4 to 8 sold the property to a third party. Therefore, my lord, I have filed an application for addition of parties, the Can number 5. My lord, that person, my lord,
after this injunction, they have sold.
after that injunction, no,
Sold.
after
So we'll
filing
come
this,
to- we'll come.
after filing this appeal,
They
after
have sold.
filing this, they have sold.
But not after the injunction order.
Not after the injunction order.
What is the
But
violation?
after the injunction order, the respondent, my lord, namely Osim Kumar De, have constructed the, my lord, structure over the plots of land, and therefore we have
Shiv Kumar Dev was not the respondent.
my lord,
Regular respondent.
Sama Prasad De. I have filed the application for addition of parties, my lord, that is can 5.
Keep the photograph with you. Why are you holding that? Like? First, finish your submissions. Shama Prasad Dey is not yet a party.
Not yet a party.
He was not yet a. So he was not a party to the injunction application at the relevant point of time. How can he commit a contempt
My lord,
or violation?
my lord, I am come.
He was not bound.
I am coming. My lord,
He have come already.
Respondent number 48 have sold the, my lord, land, subject land of the appeal and subject land of the suit.
The allegation is that proposed added respondent has been making construction. He was not a party when the injunction order was passed.
Hence, my lord, I have
order did not bind him. Till now, it does not bind him unless we add that addition of party, allow that addition of party application. Suppose even if we allow that, the violation cannot operate retrospectively. That he is added today and he violated yesterday. Retrospectively, it cannot be violated. So we'll dismiss this violation application, but we'll add. You have to serve a copy on the added party also.
Addition of party you have already served.
On the added, you are appearing for that. So we'll impose that injunction on you now also. Why shouldn't you do that? We'll do that. Use an opposition. Very well, but till then you will maintain status quo.
One thing, my lord, after this, my lord, let the, my lord, structure should not be completed. So far as, my lord.
No, we are extending the injunction on them also till disposal of this CAN 4 because he wants to use an opposition. We are adding you right now.
Yes.
After opposition to the addition of party application. Very well, till disposal of that application, then we are extending the injunction. Cannot take advantage of your own time. By these tricks are known to us.
My lord, by the instruction.
No, let him file an opposition.
My lord, by the instruction of the respondent number 48, my lord, in hide way, my lord, the respondent number 48, my lord, with a view to avoid the injunction, my lord, sold the land.
We are not of the stature of Sir Asutosh that will pass a judgment like Israel versus Shamsher. Israel versus Shamsher. We don't have that stature, therefore we don't have the guts to pass that order. That having notice of the appeal, at that point of time there was no injunction, they have sold the property, we cannot interdict with that. And the judgment of Justice Ashutosh and Beechcraft covered construction being made, not transfer. Transfer valuable rights have been created. Why should we interdict there?
Well, whole construction has not become complete now.
Construction
is going on.
I think we have made ourselves clear. Insofar as
submission there.
CAN 4 we are dismissing.
CAN 4 is entire appeal is defective. I am described for the CAN 4 application.
Entire appeal is defective.
Entire appeal.
The appeal is defective means?
I have annexed a written statement in the suit. Then defendant so many times.
What are you saying? We can't
Page.
What do you mean by entire appeal is defective?
The appeal is totally defective.
How?
By the wrong name of the parties.
The appeal is that was not pointed out by the stamp reporter.
In the written statement, they have not pointed out that the wrong names. Yes. On the basis of the judgment and degree, we have filed the appeal.
Para 5 of the
Sir, we'll consider only the fair.
defect of parties.
You let us speak also. We are deciding this CAN 4 only, whether there has been any violation of the injunction order. We are dismissing this. We are saying no violation. At the time of hearing of the appeal or by filing an independent application, you can make all these arguments. Appeal is defective, not defective, whatever. At this stage, it's premature to decide that.
One thing is I am not filed for the Bhukalatnama. Department not accept my Bhukalatnama. Two times I am Bhukalatnama.
Must be some defect in the Bhukalatnama.
The defect is come because their name. Alias
you appeared in the suit in the same name.
Yes.
You appeared in the suit, you contested the suit.
But the department of the High Court department is not accepted by Bhukalatnama, defective.
If it is defective, why should it be accepted? If they accept, then we'll rebuke them.
Bhukalatnama is defective. Bhukalatnama filed the face.
On the last occasion, On the last occasion, lordships were pleased to direct my learned friend to file the correct vocalatnama.
Do that and they'll accept.
Department says that the direction for be made, but before the lordship.
We have seen that.
Alias, you are write down for the alias. This name,
What areas?
this
Alias.
Pranab Kumar Naik, এখানে পবন নায়ক, but original name is Pranab Kumar Naik.
But this is the name as reflected in the trial court's decree also.
I will also annex for my objection. Order 18.
Let us see the decree.
Order 18 rule.
Does it tally with the decree, Mr. Adhikari?
Yes, sir.
Order 18 rule 4.
Nodding your head without checking, or do you have checked?
Then I have checked.
26
Kindly see the decree. Kindly see
The
the
cost title.
Kindly see. Kindly see.
The cost title, if the cost title tallies with the trial court's decree, then you have to file in the name which has been given here. Pabon Naik is 4.
My main name is Pranab Kumar Naik. In affidavit, order
This is
18
the
rule.
decree, trial court decree.
তৃতীয় পৃষ্ঠা লিখিত আছে তৃতীয়
We have
পৃষ্ঠা
filed the appeal, my lord, following the trial court decree. The names of trial court decree.
No, it's written Pabon Naik.
Yes.
Write alias and then file. Yes, এটা ফেরত দিন বাবু।
His original name may be Pranab Naik. How can we file the appeal?
Can 4 of 2026 has been filed by the present appellants, alleging that the order status quo dated December 1, 2025 has been violated by the proposed added respondent, to whom the original respondents have transferred the subject property, apprehending the injunction order, immediately prior to the passing of the injunction application. Injunction order. Next para, learned counsel argues that the transfer was deliberately effected after coming to know of the appellant's intention to prefer the appeal and obtain an order of injunction, and as such, was irregular. Taking undue advantage of the same, it is alleged that the proposed added respondent has started making construction on the suit property. Next para, learned counsel for the upon hearing learned counsel for the respondents, we find that the transfer was effected in respect of a third party, who is the proposed added respondent, at a point of time when no injunction order was subsisting. Hence, we do not find any irregularity or illegality in such transfer. Next para, insofar as the allegations of violation of the injunction order being made against the proposed added respondent, we do not find substance in such allegation, for the simple reason that the said third party has not yet been impleaded in the appeal, and as such, was not bound by the interim order of status quo / injunction passed on December 1, 2025 and extended thereafter. Thus, there is no scope of passing any order in Can 4 of 2026. Accordingly, Can 4 of 2026 is dismissed without any order as to costs. Next para, these affidavits are filed in respect of Can 4.
Yes, sir.
তার আগে একটা এফিডেভিট ছিল বোধহয় বলেছি না, অপোজিশন এন্ড রিপ্লাই ফাইল টু বি কেপ্ট অন রেকর্ড প্রথমে বলছি। নেক্সট প্যারা, Can 5 of 2026 is an application for addition of party. Next para, learned counsel for the appellants allege that during pendency of the appeal, the appellants have learned that the respondents have transferred the property to the proposed added respondent, namely Sri Shamapodo De. Next para, learned counsel appearing for the proposed added party seeks to use an affidavit in opposition to Can 5 of 2026. Next para, however, accordingly, we direct. Do you want to file an opposition?
Yes.
Similar prayer is also made on behalf of learned counsel for the respondent numbers 1 to 8. Next para, accordingly, the respondents are directed to file their affidavits in opposition to Can 5 of 2026 within how much time? Tell us. 3 weeks.
3 weeks.
Within 3 weeks from date. Reply, if any, shall be filed within a week thereafter. Next para, the interim order of status quo granted earlier
On 1st December 2025.
on December 1, 2025 is also extended to the proposed added respondent and shall operate until further orders. For sub next para, the Can 5 of 2026 shall be listed for hearing on September 14, 2026.
Agree, actually.
Achha, all the you are appealing for all the respondents.
All the respondents.
So have we passed directions, Mr. Udhikari, for this special messenger cost and all? We have passed.
Special officer.
Special messenger cost.
Special messenger, no.
Calcutta records and all, we are
Yes,
passing that order.
Yes,
also.
yes, special messenger cost.
That has been.
Yes. That is where a deposit.
এটা কি দিলেন উনি?
Affidavit of service.
আর বড় করে বোল্ড লেটারে ক্যাপিটাল লেটারে লিখে দাও এফিডেভিট অফ সার্ভিস ফাইল টু বি কেপ্ট আন্ডার নেক্সট
Great.
Don't be the special.
Is they brought him?
No, yes, Mr. Tiwari is here. This is 16.
Very.
This is an appeal, my lord, first appeal, my lord, from the preliminary decree of.
You agree to these amendments?
Oh, no, that is 14.
Oh, this is another one.
This is 16.
We asked you have brought him, you said yes.
Yes, that's very well. 14.
14 টা রাখুন 14 টা রাখুন এটা 16 দিয়েছেন 14 টার্গেট
Yes.
Other side is there.
14, Roy was there.
Who was appearing?
Mr. Roy was the Parthapatim Roy.
Who was his junior? ডাকুন You are agreeing to this? What? Let us see the amendment. Need not read it out. Just place the relevant paragraph. Mr. Bhattacharya.
Kindly see, my lord, the can 2, my lord, paragraph 4, 5, 6 and 7, 8 also. 4 to 8. 1948.
Can you appear in this matter, Mr. Bhattacharya? Could you?
My lord, that bench is not dismissed.
Where is Mr. Rai?
পার্থকে ফোন করুন ফোন নাম্বার আছে
Anyway, then let us call on the next matter. The পাশাপাশি থাক পার্থপ্রতিম রায় এলে তখন 16টা টাকা
এগুলো না এগুলো না এগুলো না
Yes.
Lord, this is
16 also you are appearing.
yes. This is a my lord, appeal for a preliminary decree of partition. My lord, there are two applications, one stay and one my lord is addition of party. Now,
By addition of party?
one why my lord, one of the defendant, my lord, I am my lord for some of the defendants, I am not the plaintiff. Now, my lord, he expired during my lord the pendency of the suit. The plaintiff did not take any steps, my lord, for bringing the legal heirs, my lord, on record.
For appearing for the first time?
Appearing for the first time.
The
application.
appellant shall serve copies of Can 1 of 2026 and Can 2 of 2026 on the respondents, indicating that the application shall be listed in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellants. Full-stop, the learned trial judge shall be at liberty to continue with the final degree proceedings. Full-stop, however, no final degree shall be drawn up without the prior leave of this court till disposal of Can 1 of 2026. Right. Thank you. And we'll direct also these other things. No, addition of party has to be allowed before we direct.
Yes.
Item number 17.
Yes, please.
May I request a short pass over?
No, you move the matter.
My lord,
You are for the respondent. You argue.
Lord, my senior is engaged.
Who is your senior?
Somok Bera.
Pardon?
Somok Bera.
Where is your brief? If the juniors don't have a brief, they don't have a right to ask for time. Tell your senior. We'll take up the matter. Yes, what is the matter?
Milord, it is the
Take the microphone, please.
plan 3 of my
What is it?
application of the maintenance. Milord,
Maintenance. Have you filed your affidavit of assets?
no, Milord.
File it. She is saved.
Milord, here's previously the husband was paying rupees to 28,000
You will be content with that, or you are asking for more?
more,
More.
Milord.
Then you file your affidavit of asset.
Deeply obvious.
The leave is granted to the appellant stroke petitioner to file her affidavit of assets. How soon can you do that?
Yes, Milord.
How soon can you do that?
Milord, within Friday, Milord.
Affidavit of assets within Friday?
Yes, Milord.
Are you sure?
Yes, Milord.
On the prayer of learned counsel for the appellant, leave is granted to the appellant to file her leave is granted corona. On the prayer of learned counsel for the appellant, the appellant stroke wife is directed to file her affidavit of assets within 1 week from date. Full stop. A copy thereof shall be served in advance to the learned advocate appearing for the respondent. Full stop. Next para. Composite affidavit in opposition to the alimony application and the affidavit of asset of the appellant wife shall be filed by the respondent within 2 weeks thereafter, along with the respondent's own affidavit of assets. Full stop. Next para. Composite reply to such opposition and affidavit of asset of the respondent shall be filed by the appellant within a week therefrom. Full stop. Next para. The applications shall be listed for hearing next on September 14, 2026. What is the other application?
Milord, other application was the injunction application.
We have
Yes, Milord. Yes, Milord.
injunction is subsisting.
Yes, Milord.
Next.
Deeply obvious.
Thank তাহলে pass on. Yes, Mr. Rai. You have heard him when you were not there. Yes. Advocate on record is there, so no difficulty. What will be the adjective you use for your opposition? You seriously oppose or vehemently oppose or vociferously oppose? You choose your adjective, we'll put that.
We have not filed any affidavit in reply to the affidavit in opposition.
We have not.
You have not used. Heard learned counsel. Heard learned counsel for the parties. Full stop. Next para. It transpires from the averments made in the application for condonation of delay and the application for recall that initially the appellants were in contact with their learned advocate on record in this court in respect of the appeal. Full stop. However, due to substantial passage of time in the meantime, the matter was missed by the clerk of the learned advocate on record for the appellant when the same appeared before a coordinate bench on November 28, 2019. Full stop. Accordingly, the matter was dismissed for default. Full stop. Subsequently, upon the appellants contacting their learned advocate to take information, it was discovered that the matter had been dismissed for default much previously. Full stop. Next para. The appellants also plead the ailments and critical condition of the wife of appellant number 1 during a part of the period of the delay and the pandemic restrictions during another part of the same. Full stop. Next para. Since the learned advocate on record, under whose charge the appeal was being conducted all along by the appellants, is also present before us. Please give his name also in the us, and stands by the averments made in the application, comma, we find sufficient cause for the delay having been explained, as well as for the appellants remaining unrepresented on the relevant date. Full stop. Accordingly, Can 3 of 2025 is allowed, thereby condoning the delay in filing Can 2 of 2025. Full stop. Can 2 of 2025 is also allowed, recalling the order dated November 28, 2019 and restoring SAT 346 of 2017 to its original file and number. Yes, move the appeal.
Any day next week. Any day next week.
The appeal be listed under the heading Order 41 Rule 11 on August 10, 2026. Yes. Come prepared on the appeal. Yes.
Item number 18.
Section 5.
Section 5. My lord, only one sentence. 99 days delay. Number 2, this is a
This is the second sentence. We won't permit a second sentence. You said only one sentence. We have heard you 99 days. We dismiss the application.
Huh?
99 days. We dismiss the application. There is no ground then.
No, so much ground.
So much ground.
So much.
This is appearing for the first time.
Lordship,
Appearing for the first time.
Yes.
This is appearing for the first time. Have you served copy?
No.
Then you serve copy and come back. We'll have to hear the other side.
This is a legal aid service I am appearing. So I have more responsibility here.
Definitely.
Very poor people, that is the reason.
Absolutely. We also have more responsibility to ensure that justice is given, but not contrary to the legal interests of the other side.
Obviously.
Please serve on the other side and come back.
Okay.
The appellant shall serve copies of Can 1 of 2026 as well as Can 2 of 2026 on the respondents. Only on both the respondents. What is this? Against probate?
Yes, probate.
Probate refused?
Yes.
Refused?
Yes, refused. No,
probate was
granted,
allowed.
granted.
Sorry, I'm sorry. I'm not so much.
No.
Legal aid service I'm doing so much.
Understood. But very well. Copy on the respondent number 1 indicating that the application shall be listed in the monthly list of September 2026 when an affidavit of service shall be filed to that effect by the appellant. Full stop. Next para. Service of notice on the pro forma respondent number 2 is dispensed with for the present.
I'm grateful.
Thank you. Please come back on September. In the month of September, we'll.
I'm grateful.
Yes.
Item number 19.
Right, here for that.
Yes. Respondent. No, respondent number 41. What about 1 to 40?
আগের দিন বললো সবার হয়ে দাঁড়াচ্ছে একদিন বলেছিল সবার হয়ে দাঁড়াচ্ছে বলেছিল ঠিক আছে
Yes, Mr. Kormakar, you supply the other respondents for her to get the Vakalata. You ensure that the other respondents give. There are only 63 respondents. Otherwise, you have to serve on all of them. She's doing a favor to you.
we have served upon all.
You have served upon all 63. Must be some problem with the postal industry.
Free services জমা দেওয়া আছে
Mr. Kaur, for taking the risk, you have to
I have not
ensure that all 63.
I have not checked.
Yes, Mr. Kormakar, all have been served.
Lord, it was posted service, Lord. I inquired, Lord. It was only posted with respect to services, but he.
Yes, what do you say?
আমি দেখেছি আগে
So, what do you want us to do? What is your prayer?
I kindly adjourn it, Lord. I pray for her behalf. Kindly.
How long are you practicing? How long are you practicing?
10 months. 10 months.
10 months is sufficient. You should have the brief on the next occasion. An adjournment is sought on behalf of the respondents, comma, full stop. We also find that service is not yet complete on all the respondents. Full stop. Accordingly, let the matter stand adjourned till we are putting it next Wednesday, till August 12, 2026. Please obtain the Vakalatna for the others. Ma'am, please obtain the Vakalatna for the others in the meantime. We are adjourning it till next Wednesday. Thank you. We are not taking the affidavit of service now.
But it was taken on the last.
It was already taken. Let us wait for the others.
Mr. Kormukar says that maybe some of them may not have been served, so we will have to file an
Just check up,
updated.
check up and file up.
We'll check that up.
Thank. Next.
Item number 20.
My lord, item number 20, the advocate on record is suffering from fever, my lord. I am praying for only not this week, my lord.
Litigation fever or normal fever?
Seriously.
Normal fever. Who is the appellant, advocate for the
Miss Shomi Goho Thakur.
Very well. An adjournment is sought on the ground of ailment of the learned advocate appearing for the appellant. Let the matter stand adjourned till Monday.
Monday, my lord. My lord, in the cost list, there is some defect is written, my lord.
Defect is there?
But I have been informed that there is no defect.
What's a defect? Yes, you have to check up the defect.
Yes, ma'am.
Name of the defendant numbers 7 Gho to Wo. Gho and Wo. Ramohari and Kalpana Rani Das is not there in the trial court's degree. So please tell the advocate on record that 7 Gho and Wo of the trial court of this court are not, their names do not find place in the trial court's judgment or something like this. So please ask her to check up.
All right.
We are adjourning till Monday for the time. যেখানে ছাড়লাম ওখানটা till August 10, 2026. You give your name, Atal and Atkuda. আচ্ছা না ছেড়ে ওটা বোঝা যাচ্ছে না ট্রায়াল কোর্টের রেকর্ডের ডিফেক্ট কিনা পরে দিন।
21.
Yes, 21.
My lord, I will wish to appeal, my lord, for the appellant in this matter.
Yes, but why are you having a questioning look? I mean,
Lord, the brief, Lord.
Oh, you don't require a brief, Mr. Komar. Your stature, with your knowledge of law and your knowledge of facts, please apprise us what is the.
Absolutely. No, my lord,
What is the matter
last
about?
occasion.
See, we were right. Yes, on the last occasion, what happened?
On the last occasion.
Don't open the book. Tell us.
On the last occasion, there was a direction for rectification of, my lord, the records. Lord, it has been done. A fresh report is, I understand, my lord, is there before your lordship. Lord, whatever rectification we had to do, my lord, we have done,
Yes, right.
and the rest are my lord, have to be
We have to send.
sent.
So let us see a second appeal.
Second appeal, my lord.
So let us
Judgment of
dismiss the appeal
affirmance.
and then direct it to. Yes, move the
Judgment
order
of affirmance.
affirmance. Good. Eviction.
No,
my lord, eviction.
আমার মুখটা কই?
What is the matter, Mr.
Yes. Lord, the point.
No, you take you. You have your notes. Must be in that. এটা কি এই ম্যাটারটারই? এটা আগেরটা রয়ে গেল। অন্য ম্যাটার। আগেরটা রয়ে গেল ভাগ্যিস। Yes, Mr. Komar.
Yes. Lord, the suit, my lord, is for declaration.
আচ্ছা, before you proceed, একটা লাইন না লিখে দাও, the trial the records be sent down for effecting necessary corrections as pointed out by the stamp reporter. The matter is taken up for hearing under Order 14 Rule 11 of the Code of Civil Procedure. Yes.
The suit is for declaration of title that the plaintiffs are owners of certain amount of shares.
You are the plaintiffs or the
Lord,
defendant?
I am for the defendant number 4, only defendant number 4.
Right.
And Lord, appellant in the trial, in the learned appellate court below, add Lord here.
Obviously, yes.
Now, Lord,
Declaration
that they are owners of certain portion of share.
Certain number of shares.
Yes, number of shares. And my lord, also injunction that based on a record of right,
Yes.
my lord, that the defendants or we cannot claim any, my lord, interest over the land.
Share of land.
Share of land. Now, my lord, my first argument for your lordship would be that this suit is itself not maintainable because no partition was not
necessary.
One.
Not necessary.
The second aspect, which was not looked into by any of
I can ask for a declaration of share. I may not want a partition.
Lord, when
that's not necessary under the proviso to 30.
Yes, Lord. The Supreme Court says, my lord, in a situation where party is asking only declaration, no difficulty. But if there is an injunction, then, my lord, the partition has to be asked for. Because then you are asking, then you are not trying to stay together. Once you ask an injunction against a co-sharer,
What is the nature of injunction asked here?
not nature of injunction is not to disturb possession. The other one is on the basis of record of right, so that not the defendants do not claim any right, title, interest. I'll just read it out for your lordship. Print.
Have you got a copy of the annex?
Yes, not it's not annexed, Lord. I'll just print a copy.
Why don't you annex a copy of this? This is your chamber. Your chamber.
Yes, my.
Why don't you annex a copy of the print? And he has been described in the back sheet to be under your care.
Yes.
If you have one copy, then you have to choose the judge. That's our principle. And the other judge will pass the order.
আরেকটা কপি প্রিন্টের কপি সাজিয়ে রাখতে বলেছিলেন।
একটাই copy, obviously. Read out the
read it out,
please.
আর্জির লিখিত হেতু বাদে নিম্ন তফসিল বর্ণিত সম্পত্তি বাদী পক্ষের রকম ৮ আনা অংশ সত্য সাব্যস্ত পূর্বক তাহাতে বাদী পক্ষ বিবাদী পক্ষের বিরুদ্ধে যৌথ দখলের ডিক্রি দিয়া বিবাদী পক্ষ যাহাতে বাদী পক্ষের রকম ৮ আনা অংশে সাব্যস্ত স্বীকার করিতে না পারে, কি ৮ আনা অংশে যৌথ দখলে কোনরূপ বাধা বিঘ্ন ঘটাইতে না পারে, তন্মর্মে বাদী পক্ষ বিবাদী পক্ষের বিরুদ্ধে চিরস্থায়ী নিষেধাজ্ঞার আদেশ সম্পলিত যথাবিহিত ডিক্রি
So he is taking injunction regarding only his 8 anna share.
8 anna share, and so that I cannot
and he is asking for a declaration of joint possession.
My first point with your lordship is as soon as an injunction is sought for in an undivided property, the consequences without partition, the suit is not maintainable.
All right.
That's the first. The second is, for that I need to place.
Yes, the judgment.
No,
the second point.
Genealogy, the second point.
The first one you say there's a Supreme Court judgment, you have it?
Yes, it's there.
We'll look into it. Let us hear it. Yes.
The suit property was originally
purchased
by Baldev Singh, Lokhi Singh and Ramnath Singh.
Right.
Thereafter, due to the promulgation of the West Bengal State Acquisition Act, at that point of time, only Kanta Singh, your lordship would find Baldev Singh had 4 sons.
Yes.
Raghunath Singh had 1 son, defendant number 5.
We have found Kanta Singh.
Yes, Kanta Singh.
Yes.
So, only Kanta Singh's name was recorded in the record of rights as Korfa tenant.
All right.
So, immediately on the date of vesting,
suit property belonged to Baldev, Lakshmi and
Ramnath Singh, and in possession it was recorded as Kanta Singh on the date of vesting.
At that point of time, the original owners were, the purchasers were still alive.
Yes. Baldev Singh.
Why was Kanta Singh's name recorded?
He was named as because he was in possession of that property.
Very well.
He was Korfa tenant. Name was recorded, and subsequent to that, under Kanta Singh, as Onumoti Dakholkar, the defendant number 4's father was recorded as Onumoti Dakholkar.
Who is the defendant number 4?
Defendant number 4 is Kabej Ali. That is, he is the appellant before your lordship.
Very well. His father was recorded as the permissive occupier.
Yes.
Right.
Now, what happened? The plaint proceeds on the basis that this Ramnath Singh, Lokhi Singh died, so as a bachelor, so his 50% went to 2 brothers.
Lokhi Singh was a male.
Yes, male.
Bachelor.
So his 1/3 divided. So 50% to Baldev and 50% to Ramnath.
Right.
From the heirs of Ramnath, the plaintiffs have purchased.
Who are the plaintiffs?
The plaintiffs have purchased from Indrajit Singh, Vinod Singh, Jairam Singh, Rajkumar Singh.
Very well.
So from these 4, the plaintiffs have purchased the property.
So they could not have sold the entire property because Dev Pujan, Shiv Pujan and Ram Pujan were also there.
That's why 50% have been claimed, 8 anna share.
50% of Ramnath.
Of the entire suit property. Because the property was owned by 3. 1 died.
Ultimately it became half and half.
Half and half.
Ramnath owned
from
half.
Ramnath's portion.
So, but Ramnath among Ramnath's heirs, you said only Indrajit, Vinod, and Jairam, the second tier, they sold to them.
Yes, Milord, all the
All heirs.
all.
So
Including
50%.
Ramnath,
Plaintiffs have 50%.
50%.
That's an
the plaint
admitted question.
case. No, that's a plaint case.
Yes.
Now, Milord, I say on the date of vesting, that's on 1954, Milord, the entire interest of this Ramnath and Baldev, Milord, it went to the state. It vested with the state. Now, Milord, the person in possession, because of the Land Reforms Act, Milord, he became the actual owner of the property. So, Milord, Kanta Singh became the owner of the property. Now, Milord, if Kanta Singh is the owner of the property, then, Milord, the issue with respect to whether Ramnath's 50% devolved upon the plaintiffs or, Milord, I am the 50%.
How was it dealt with by the courts? Both the courts?
This point was never raised.
You did not raise it?
No, this is the point of law, Milord, if I may indicate. This is a point of law.
Or for tenancy is a mixed question. Cannot raise it.
No, that has been recognized.
Oh.
Yes, that has been not recorded. That based on record of rights, no title passes. Those things have been done.
Or for
But this
tenancy was
aspect, record of rights was produced. It has been recorded in the Milord.
and the courts, both the courts view was that on the basis of record of right?
Nothing. Now, Milord, may I take your lordship to the findings? Memo.
For a change, you appear to have a good question involved in.
My luck, Milord, all bad.
Your client's luck also. Yes.
Milord, may I take your lordship to the trial courts, Milord?
The relevant portion only.
Yes.
You can, it's a judgment of affirmation, you can take us to the appeal, first appellate court. Unless there is something completely new.
Same thing. Because the defense was, Lord, my sale deed is prior in time than the plaintiff's deed. That was the issue. And the
you also have that sale deed?
Yes, I have a sale deed. They have also executed a sale deed.
So if you have a sale deed, then you
that is also inconsequential.
No. Then you admit that you are not the
My admission does not take away the title. It is by operation of law that the title is coming.
You purchase the property from whom?
From Lord Ramnath and all. But then again, that the court went on a different thing on Mitakshara law.
No, Mr. Kormukar, if you purchase the property, you cannot purchase the property of which you are the owner.
That's exactly what I'm saying. And not only me, Lord, the others were also there. Not only me, the others were also there. The sale deed has been held to be void. My sale deed has been held to be void. Because
it's a subsequent deed.
My sale deed was prior in time, but the property is situated in Bengal, executed in Bihar. Not how, I do not know, but it was done.
Sale deed executed in Bihar. Why held to be void?
Lord,
the sale deeds executed in Bihar are void.
Stamp duty. No, stamp duty has to be paid in.
You did not regularize it by paying the stamp duty here also?
Nothing like that. And that's not a completely different.
Their deed was registered here.
Their
stamp duty, does it invalidate the deed? Render it invalid?
Lord, if it is not stamped.
What is the effect? It was a registered document.
Registered document. But unless and until it's stamped, neither it is admissible in evidence, nor it creates
not creates any right.
Stamp, so it is not only inadmissible in evidence.
So was this findings?
Yes.
You can start with the finding of that your deed was void.
But kindly first come to page 6 of the appellate courts, Lord.
Yes.
Admittedly, the erstwhile owner of the scheduled property were Baldev Singh, Lokhi Singh, together with half share therein, while Ramnath happened to be the owner of the remaining half share, such and such. The exhibit testament of such and such, it was the contention of the plaintiffs that Ramnath Singh, co-owner's half share goes on for Mitakshara. Para 8 turns over. The same story, Now, Lord, kindly comes to page 17.
Who sold his share to you?
Lord,
Who sold his share to you? the heirs of the same vendors as the
Ramnath.
Ramnath himself. Yes.
Lord, kindly comes to page number 17, internal page number 17.
Internal page number 7.
17, 17, Lord.
17 years.
The evidentiary value of record of rights is the best, is
At
at
best.
best prima facie proof of possession of a piece of property.
So this court for tenancy was
This
overlooked.
was shown. This was shown, but this was not, Lord.
That was dealt with in this manner.
Yes.
No, court for tenancy এটা আলাদা হচ্ছে, legal effect আলাদা. And what about that your invalidity of a sale deed?
Lord, invalidity of the sale deed, your lordship would find page 19, 19, Lord. 18, paragraph number 18. Admittedly, the deed that is executed and registered earlier has to be relied upon, provided other considerations satisfied. That on parameter exhibit A, which was executed on 19th of May 1981, would appear to override deeds of 23rd. Lord, 19th of May is my deed, and 23rd May is, Lord, of the plaintiff's deed. This court is also not unaware of the provisions of section 28 of the Registration Act. It specifies that place where documents relating to land must be presented for registration. Section 28 mandates that such document must be submitted to the officer registrar or sub-registrar includes entire or a portion of the property mentioned in the
Registration Act.
registration.
So the registration was also it's found to be vitiated,
Yes.
not only stamp. 28, what is the effect? Let us see.
Registration Act. I bet.
Section 28 is a good ground. I mean, not for you, against you. Sale deed is apparently vitiated, so court for tenant and that partition 34. The present second appeal will be heard on the following substantial questions of law. One, whether the courts below failed to take into consideration the legal effect of the recording of the name of defendant number 4 stroke appellant as a Corfa tenant, comma, which indicates vesting of the property in the state, comma, which subsumes the title of the previous owners and their transferees, comma, in arriving at the finding that the records of right do not create title. Roman 2, whether, comma, in view of the plaintiffs stroke respondents having categorically asserted their separate rights in respect of their 8 annas share in the suit property and having sought in permanent injunction in respect thereof, comma, the suit was barred by the proviso to section 34 of the Specific Relief Act 1963 as amended, comma, in view of absence of any prayer for partition, full stop. Full stop. These two. The deed we are not touching now because registration apparently was a good. So any interim
Lord, there is an application, Lord, for injunction. Lord, they are by virtue of this order, Lord, they are trying to get into the possession, and Lord are Lord trying to start PC culture in the pond.
Lord, culture is obsolete in our state now.
Lord, supplementary affidavit. I mean,
what does it say?
Lord, only to that extent, Lord, that was missing. This has a
was missing.
But this was subsequent development. Lord, at the point of time when this application was filed, Lord, they were not emboldened with.
No, but nature and character. What is the
nature and character? Lord, my injunction application kindly, Lord, can one.
Yes.
Nature not to sell, alienate, nature character will not change, Lord, and not to deal with the property.
That will pass. And what about can 2? Stay.
Not can to stay has been
Stay of decrease of preliminary degree of partition.
no partition. That's
Oh,
my,
sorry.
that's my point.
Yes.
Lord.
Declaration of title and permanent injunction also.
Yes.
We cannot stay there. But permanent stay means
Yes. Allowing that.
very well. We are dismissing your 2 first, then we'll take up.
Right.
Can 2 of 2026 is an application for stay of operation of the impugned judgment and decree, whereby a declaration of title as well as permanent injunction has been granted. Full stop. Since grant of stay of operation of such a decree would tantamount to allowing the appeal insofar as the prohibitory injunction passed against the appellant would then stand virtually reversed, comma. There is no scope of grant of any relief on the said application. Full stop. Accordingly, can 2 of 2026 is dismissed without any cause. Full stop. Next para. Insofar as can 1 of 2026 is concerned, comma, from the averments made therein, we find sufficient prima facie case having been made out for grant of injunction. Full stop. Also, comma, the other tests of grant of injunction are satisfied per se, satisfied prima facie on the basis of the allegations made in the application. Full stop. Accordingly, the respondents and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, encumbering, and or creating any third-party interest in respect of the suit property till disposal of can 1 of 2026. Full stop. Affidavits in opposition, if any, shall be filed by the respondents to can 1 of 2026 within 3 weeks from date. Stop. Reply if thereto, if any, shall be filed within a fortnight thereafter. Full stop. The application shall next be listed before the appropriate learned single judge having determination, comma, subject to being mentioned by the parties after the timeline for filing affidavits is over. প্রথমে এই যেখানে সাবস্টেন্সিয়াল কোয়েশ্চন অফ ল ফর্মুলেট করলাম তার ঠিক পরেই সাপ্লিমেন্টেড এফিডেভিট ফাইল টু বি কেপ্ট অন রেকর্ড, আর যেখানে কপি সার্ভিসের ডিরেকশন করেছি copies of can 1 of such and such along with a copy of this copies of the supplemented affidavit filed today. An affidavit of service to that effect shall be filed by the appellants on the returnable date.
Written.
বইটা কাছাকাছি থাক যদি আবার লাগে।
This is my appeal,
Yes.
my lord. What happened is
Lost a caveat, but no copy has been.
কবে action given?
An application.
caveat check হয়েছে তো
Oh, there was no correct.
অ্যাপিলে ছিল সিও তো ছিল
না লিখেছি
Anyways,
মানে what happened, my lord? The
Caveat-
appeal against the section
By
5.
mistake, they have filed a
oh,
earlier.
Earlier I preferred
caveat, caveat endorsement is there. So there's a section 5 also.
no section 5
So
against
there's
the section 5, my lord. My
Oh.
section 5 application was dismissed in connection with the appeal.
You better serve a copy because we may hear out the appeal itself.
Yes. No, we have no.
We agree. Mrs.
No, that
Kapoor,
is
if it's
not-
come prepared, if it's against dismissal of section 5, either we dismiss it under order for rule 11. If we admit it, then no useful purpose will be served for you in keeping it pending for years. And then we can consider 2-page order. We can consider if we admit the appeal, we can consider whether we can dispose of the appeal also. You come prepared, we'll keep it on Monday. You please give a copy of the application and a copy of the memorandum.
No, defect is there, my
Oh,
lord.
we'll just check.
Yeah, copy please, yeah.
Trial court details have not been given. Oh, trial court in the preamble, trial court details have not been given. Thereby affirming and all these things, please incorporate those. And secondly, trial court decree is also not there.
This is rejection of section 5.
Even then, effect is appeal is dismissed. So trial court decree is affirmed. You have to file the trial court's judgment and decree. How soon can you get it? Because that was filed with the appeal.
Yes,
You can take that back. You know, you can take it back from the appellate court. Should we keep it after 2 weeks?
time লাগবে তো মানে problem is, well, they put execution case before the learned court below.
When is the next date?
14th.
Next date 14, well,
Send it to try to withdraw the certified copy from the first appellate court as soon as possible. We'll keep it on 11th, Tuesday. We are keeping it on 11th.
Unless the order is there, that first appellate court, there will be a problem to take.
No. You just have to file an application. Mr. Chakraborty will help you. He will.
They will not oppose.
He will engage his resources too, so that you can, and you have to pay the resources.
Client will not oppose that.
First
Mr. Chakraborty, please help him out in getting the certified copy from the trial. Which court? Hooghly. You please help. Sirampuri, please help.
We will ask them on furnishing.
Since a caveat has been lodged, comma, the appellant shall serve copies of Can 1 of 2026 as well as the copy of the memorandum of appeal on the learned advocate appearing for the respondent, caveator stroke respondent by tomorrow. First up, the matter shall next be listed under the same heading on August 11, 2026.
August 11, yes.
11.
In the meantime, we shall take proper
Next
step
Tuesday,
to
please.
take up, yes.
The leave is granted to the learned advocate on record for the appellant to rectify the preamble of the memorandum of appeal in terms of the report of the additional stamp reporter, as well as file certified copies of the judgment and decree of the trial court on the returnable date. Please effect the corrections in the memorandum by giving.
My junior will take appropriate step. Correct down.
Yes.
Item number 23.
Yes.
For the appellant, Can 3 has been filed, however, it's not appearing in the list. May I just
It's not appearing in the list.
No, it's not appearing in the list.
Today it has been filed.
Yes, my lord.
How can it appear in the list?
My lord.
What is Can 3?
It's continuation of delay, my lord.
That has to come first. We'll take it up on Monday.
Monday. I'm deeply obliged.
You have got copies of everything?
My lord, I have got
Can
copies.
three,
I'll
but
serve.
I'm told it just served today. But maybe come back with the opposition.
You can file. No. What is the delay?
My lord, 6 days delay. My lord, there is a scope of interim.
While opposition, Mr. Kormaka will impose heavy costs on your client as well as on you personally. Yes. On the let Can 3 of 2026 be listed along with the present appeal. Push of the matter be listed next on August 10, 2026.
I'm deeply obliged.
24, Your Lordship, I am for the appellant.
Yes, Mr. Shenmugh, what is the matter?
Yes, Your Lordship, continuation of yesterday's argument. Your Lordship, kindly come to page 38 once. Partition suit as well as Your Lordship declaration that the development agreement, Your Lordship, is not valid. Your Lordship,
Just remind us once, Mr. Shenmugh, you are the plaintiff there.
I am the plaintiff there. I filed a suit for partition as well as the declaration that the development agreement, Your Lordship, is bad. The reason is, Your Lordship, that my mother's share have not been, Your Lordship, recognized. Basically, Your Lordship, the dispute is between me and my mama. Mother's, Your Lordship, brothers, maternal uncles, and all the sisters have been, Your Lordship, precluded from, Your Lordship, the succession, and the development agreement has been executed.
Your sisters, mother's sisters.
Brother, sisters. All my mother as well as the Your Lordship, my Masis, Your Lordship, have been excluded.
Achha.
Totally. Lordship, kindly take once page number 38.
38 you have got?
Yes. 38, Your Lordship. I am, Your Lordship, Bishwajit Rai.
No, who are the other respondents?
The other.
All are your mamas?
No, Your Lordship. Defendant number 2, respondent number 1 and 2. Your Lordship, Gautam Burman and Siddhartha Burman.
The others are the developers or what?
No, Your Lordship, the developer is the respondent number 18. I have implemented the respondent.
So who are the middle people? I mean, the Meheras?
They are, Your Lordship, the heirs, Your Lordship, of the other sisters, as well as, Your Lordship, the other brothers.
But they have been deprived.
The only deprived, Your Lordship, kindly sees Ganga Devi, Geeta Khamu, Nomita Burman, Sobita Royce, Lalita Burmans. These people, Your Lordship, have been completely excluded.
All the sisters have been excluded.
Completely excluded.
All the brothers have got their shares.
All the brothers, Your Lordship, have executed, Your Lordship, a development agreement in favor, Your Lordship, of the respondent number 18.
So you have challenged that and asked for...
I have challenged the development agreement and as well as, Your Lordship, I have asked for a partition of the property. Now, on that basis, Your Lordship, ex parte ad interim order was refused.
What injunction did you seek?
I seek, Your Lordship, that no third party interest as well as, Your Lordship, the
nature
and character as well as the construction. These are the things. Now, the Honorable Lordship, the learned trial court found that
Yes.
I don't have any right, I don't have any documents in connection with my title as well as possession. Possession I cannot have. The possession is very simple because married sister, I was staying outside.
You are not asking for injunction regarding possession also.
Not possession because this is a development, property is developing. So I want only the injunction over your
What
lordship.
about title?
Title. Now, what I can do, I have only given your lordship all the PAN card, Aadhaar card of my mother, where your lordship, the relationship can be established. That the Jagabandhu, your lordship.
Prima facie sufficient proof was there.
Yes.
And the predecessor's title they are automatically admitting because they claim to the same predecessor.
Yes, sir. Now, what happened, your lordship? Kindly, your lordship, before your lordship making any submission by the other side, lordship, kindly take once the development agreement.
Yes.
This is your lordship, the documents. Your lordship,
Not annex that.
My fault, your lordship. I could not, but these are the documents. I can also give them a copy.
Give them a copy, otherwise they'll not know what you are.
Documents list. Lordship, kindly take your lordship the development agreement first.
Yes.
Page number 2 is the development agreement, and the relevant portion. Your lordship, kindly take page number 6. Lordship, kindly take first page number 6. Or rather, yes, your lordship, 6. Lordship, kindly take just below 4 lines. After the death of the said Amod Lal Bormon and both Pramod Lal Bormon, the sons of Jagabandhu Bormon, namely Gopinath Bormon, Goloknath Bormon, Poreshnath Bormon, and Devnath Bormon, became the absolute owners and possessors in respect of the property mentioned in the first schedule below.
So you have been obliterated from the
completely. Now, kindly take your lordship page number 38. Jagabandhu, your extremely right hand side. Jagabandhu expired, leaving behind Gopinath, Goloknath, Poreshnath, Devnath. These are the sons. And the daughters are Ganga Devi, Geeta Khumu, Namita Burman.
13.
Page number 38, your lordship. Just I want to match your lordship with the genealogical table. 38 of your lordship, my stay application.
Of the stay application?
Yes, your lordship. And now your lordship kindly match.
Yes. Yes, these the daughters have been excluded.
So therefore, there was nothing your lordship mentioned in the development agreement that I was excluded or ousted by way of a testamentary document. This prima facie shows from your lordship this particular document.
This was a ad interim refusal.
A final refusal.
Ad interim was refused?
Ad interim was also refused. Final was also refused. Your lordship, kindly sees the final order once. There is no whisper that I have been ousted. There has to be some, your lordship, at least.
No. Before service of notice.
No, your lordship, ad interim refused, and thereafter the final injunction application was also refused.
2024, final order
21st of February 2026, your lordship, is the final order.
You are challenging that?
I am challenging that. And your lordship, kindly sees the next page.
What did they see in the written objection? Say in the written objection?
The written objection, there is only one paragraph. Your lordship, kindly take. Your lordship, he wants to go with me.
One paragraph?
Only one paragraph. No, your lordship, they have dealt with, but one paragraph they have, your lordship, mentioned regarding the type. Paragraph 11 and paragraph 12.
10 to 14.
10 to 14. Let's come to 10 to 14.
Well, he is placing only 10 and 11. I should say 10 to 14.
No, but I have been ousted.
We'll see all.
Yes, sir. Paragraph 10.
Yes.
The defendant number 1 and 2 further begs to submit that the property as specifically described in schedule, they detail in the schedule portion of the plaint originally belonged to one Bimala Sundari Devi, since deceased, who got the same along with the other properties from her husband, namely Hiralal Bormon, since deceased, by virtue of a will executed and probated in the year 1980. And as per the spirits of the will, whole schedule mentioned property in the plaint, that is total 16 anna portion of the share devolved upon her. That subsequently the said Bimala Sundari Devi, during a lifetime, transferred the whole schedule mentioned in favor of the two minor grandsons, that are Gopinath Bormon, since deceased, and one Goloknath Bormon, since deceased, by making a separate instrument, that is a will come gift endowment in the year 1933, and appointed one Jogobandhu Bormon, since deceased, as an executor of the will, as a mere custodian of the property, till the said Gopinath Bormon, since deceased, and one Goloknath Bormon, since deceased, attains majority. That thereafter the said Gopinath Bormon, since deceased, and one Goloknath Bormon, since deceased, accepted the said will come gift endowment after attaining majority, and since then they start to enjoy and possess the said whole schedule mentioned property. The said Gopinath Bormon decided to remain bachelor, and his full-blooded brother, namely Goloknath Bormon, since deceased, got married in the meantime as per the family settlement and arrangement. Prior in the year 1956, his portion of half share devolved upon his only married full-blooded brother, namely Goloknath Bormon, since deceased, so that the property in dispute could be carried forward to the future generation following Mitakshara law, as per the spirit of the aforesaid will come endowment executed by the said Bimala Sundari Devi, since deceased. This is his explanation.
So Goloknath got everything according to them.
Yes.
They are claiming through Goloknath.
No.
Then what happened?
So Gopinath and Goloknath.
Gopinath died.
Yes.
Para 13. Gopinath decided to remain bachelor as his full-blooded brother. Since his, acha. Sorry. The other way around.
Yes.
Goloknath died.
Gopinath died.
That said, Gopinath Bormon decided to remain bachelor as his full-blooded brother, namely Goloknath Bormon, since deceased.
Gopinath died intestate without any legal heir and
In
succession.
para 13, you have stated Goloknath Bormon since deceased.
The said Gopinath Bormon decided to remain bachelor. Yes. And his full-blooded brother Goloknath, since deceased, got married in the meantime as per family settlement and or arrangement prior to. So Goloknath.
Full-blooded brother, namely Goloknath Bormon, since deceased.
Goloknath has died. Now Goloknath.
Yes, that is what we are saying.
Yes, Goloknath's heir are Gautam and Siddharth, who are defendant number 1 and 2.
What does this mean? Said Gopinath Bormon decided to remain bachelor.
Yes, Gopinath.
As his full-blooded brother, named Gopinath, got married.
Since both died, now both are deceased. Gopinath and Goloknath deceased, but Gopinath has no legal heir or successor, unmarried, and the portion of Gopinath devolved upon Goloknath. Goloknath heirs are Gautam and Siddhartha, who are respondent and defendant number 1 and 2 before your lordship.
All right. For whom you are appearing?
For whom I am appearing.
Other defendants are not represented before.
Other defendants have.
You have lost caveat.
They have lodged caveat, your lordship. That's why I have served to them.
Naturally. So you have lost caveat. Right.
Now, this entire thing, your lordship kindly sees the order impugned. There's nothing, no description, nothing, your lordship, that I have, my entire portion has been completely excluded.
Now, if they produce some will or something, will.
But that has to be scrutinized, your lordship. Even your lordship, they have filed it one firisti along with the document. But in the order, at least, your lordship, that.
Did they produce a will?
Lordship, that at least not to me, your lordship, they have not given. But I suppose, your lordship, they have, if they have filed before the court of law, your lordship, that would be firisti.
Not brought it. In the trial court, did you file it?
But so far as the production of documents is concerned, that is not reflected in the
Not reflected, yes, exactly. That is why we asked.
I have taken instruction, those have been filed by way of a firisti. But the prima facie, but the learned court below went on that he could not prove his document to title and possession. That is the
possession, we agree. And possession, we say that is immaterial here, because they are asking for
partition.
Not only
by one is a possession of the
not only that, here they are not also asking for injunction regarding possession, and we will also not grant them, because possession we are not granting anything regarding transfer, change of nature, character only. The here learned trial judge has held, Mr. Vasu, that after going through the petition and written objection, they have produced a genealogical table. They have averred on oath that they are the daughters. They have produced Aadhaar cards or some documents, very prima facie documents, to show their identity as daughters or sons, daughters of somebody. Now, predecessor in interest is common. It's an admitted position.
But entire property has devolved upon defendant number 1 and 2.
That is your case, but no probate. Is it your case that in probate has been granted?
Yes. Probate has been.
Have you averred that?
Yes, in the year 1918, subsequent.
That you have said in your objection also.
1918, there was
so trial court had to consider those.
May I just indicate to lordship? If my lord may kindly take.
There is no consideration in the impugned order. How can you look into these?
My lord, so far as the document been produced, my submission is that entire document list of documents encloses the probate of 1918, subsequent of 19.
Has to be adverted to by the trial court. At least prima facie have a look at that and say one line.
May I show to your lordship here, my lord?
No, because the trial court had to say that. That is the first court that has to exercise first. At least one line should be devoted to the fact that you have produced probates, and trial court says that no,
Prima facie, if I can show to your lordship that the plaintiffs and other defendants.
we cannot improve the situation. This is a wrong which goes to the root of the order, Mr. Basu. The trial court only on the basis of they having not proved the title.
Yes.
If probates
of the title, if I can
exactly, you also have title, and their suit is you are asked for
I have a better title than the plaintiff and other defendants. Absolute title.
apart from the probates or the wills, you have equal title. The sons and the daughters have equal title because the title of a predecessor, common predecessor, is Bimala Sundari. That is admitted by you.
Yes, but
so they also claim through Bimala Sundari. They need not
yes,
prove.
Bimala Sundari have executed a will only in favor of defendant, only in favor of.
You're not understanding, Mr. Basu. You're going on repeating the same thing. You're not understanding what we're saying. We started with the rider that in the absence of any probate or any will being adverted to by the trial court, we cannot look into that will. It has to be adverted to. It's a fundamental error in the trial court's order. In the absence, if suppose there was, Mr. Basu, either you listen to him or you answer to our query. We'll give you one last chance. If you can see this continuing, that will just stop your arguments and just pass our order. You are making it very clear to you. Either you take your instruction, do your conference, and then take your instruction, please. Please take your instruction and then answer us.
I'm sorry.
No, we are serious. So please take your instruction. In the middle of this will be repeated.
Your lordship.
No, you are not to argue. One of you will argue.
I'm sorry.
Now listen to us, please. Mr. Basu, we are saying if there was no probate, no will, then the case remains that from your written objection, it's evident that you are admitting the predecessor in interest title. So therefore, they need not have proved title separately. What comes in the way is your wills and your probates. Trial court had to devote one line to those probate or will being produced before it and see it prima facie satisfied. On that ground, if injunction was refused, we could not have anything to say. Nothing said, they failed to prove their objection, but by claiming through Bimala Sundari, through the wills, you admit Bimala Sundari's title. This is our question to you. What is your answer?
Well, in so far as my submission will be, my lord, Bimala Sundari is undoubtedly the successor in predecessor in interest. Bimala Sundari got the property from his husband by way of a will.
Yes, that is their case also.
Bimala Sundari executed a will. So far, her portion is concerned, my lord, appointing Jagabandhu Bormon as the executor, the last son, Jagabandhu Bormon, that is the son of Jivan Lal.
Mr. Basu, have you stated in your written objection, have you denied that they are daughters or they are in any way related?
But in my preceding paragraphs, I have denied entire fact.
Show us, no, specific denial that they are not she left behind only the sons, that this person left behind only the sons. Have you stated that?
Well, so far
you are all Jagabandhu's heirs.
Yes.
All of you are Jagabandhu's heirs.
Jagabandhu's heirs.
So have you stated categorically, Mr. Basu, show us the paragraph where you have stated Jagabandhu left only you as heir?
If my lord may kindly see.
There was no daughter.
If my lord may kindly see the paragraph 10, your lordship has.
10, yes.
The defendant number 1 and 2 further beg to submit that the property as specifically described in details in the scheduled portion of the plaint originally belonged to one Bimala Sundari.
Bimala Sundari, everybody admits.
But since deceased who got the same from the other with other properties from her husband.
Then you go on to the will.
Yes. Thereafter, my lord may kindly see paragraph 11 that subsequently said.
No, we have seen up to paragraph 14. There is no denial that they are daughters.
My lord kindly see, my lord, paragraph 15 and 16 thereafter. That subsequently said Goloknath Bormon died intestate leaving behind his wife Bela Bormon since deceased and his two sons answering defendant number 1 and 2 of the instant suit. Thereafter said Bela.
In your entire written objection, Mr. Basu, you have avoided denying that they are daughters or that Jagabandhu left behind any daughters. You have not denied that anywhere.
But so far as the plaintiff in the foregoing paragraphs, if my lord may kindly considers paragraph 7. Paragraph 7, I have dealt with the entire or detail of the injunction application whereby the inheritance has been sought to be made or the case made out in the plaintiff.
Read it out where you have denied their daughtership.
It's a big paragraph, may I just indicate to you?
Yes.
Which paragraph 7, internal page 2.
Yes, we are there.
Which in hereafter referred to as a showed property or that the fully described in the schedule hereunder originally belonged to Bimala Sundari. That is the case made out in the plaint and the injunction application.
Yes.
Amod Lal, Pramod Lal, Jivan Lal. And
you have quoted the entire thing and just denied.
Yes, I have denied it that this factum of the Inheritance.
This is evasive denial.
But
The entire thing you have quoted and said I am denying.
I am denied, and now my case has been made out in paragraph 10 to 16 onwards.
Right, but those cases do not say, there is not a single sentence devoted to saying that Jagabandhu did not leave any daughter. They are not the daughters. We wanted 1 or 2 lines on this. You have evasively denied it.
As far as Jagabandhu's daughters are concerned, I do not say that they are not the daughters. What I see,
Then automatically their title is proved.
no,
Unless the wills come in the way which have not been adverted to by the trial.
no, I cannot say that they are not the heirs, they are not the daughters of Jagabandhu, because they are born out of.
Then they need not. The trial court's premise is wrong. The trial court says they failed to prove title. They need not prove title separately. Their title is automatically proved by your averments also. If the wills are not in the way, you say you have produced the wills. We don't find a single line devoted to that.
That in my
We'll remand that. We'll ask the trial judge to advert to those.
May I just indicate to Lordship, my Lord, the last but second last paragraph
Of the impugned order?
of the impugned order.
Yes, please.
In order to
Second page.
yes, my Lord, the first page of the impugned order.
Yes, in order to
In
substantiate.
order to substantiate the claim of the plaintiff, the landed counsel appearing for the plaintiff submitted some documents by way of fiduciary and relied upon judicial precedents. Par contra, to support the contention of the defendant, landed advocate also filed documents by way of fiduciary and further relied upon judicial precedents. But these are the documents of the will and the will of 1918 and 1933, from where the only Jagabandhu's legal heir has been given bequeathed with the property, from where defendant number 1 and 2 inherits. In exclusion of
You have to explain what was the reasoning in the mind of the trial judge, then it's a bad order.
but that
You cannot explain.
that is in the
You are not at fault. We are not saying your client is at fault. It's like that story of Gopal Bhatt. He was asked to write a letter to his aunt, and he said, I have a problem in my feet. So what is how is that relevant? Because I have to go and read it. If you have to come and read the order of the trial judge, then Mr. Basu, it has to be reflected somewhere. He says merely, he or she, we don't know. Per contra, to support contention of the defendants, learned advocate for the defense counsel also filed documents by way of fiduciary. Fine, we understand. You might have filed the probates or the wills. Then he goes on to say, after passing through the whatever that means, this court is of the view that the plaintiff failed to file any document of possession and title to prima facie prove the contention as projected in his application. And then order 1, rule 10, etc.
Order 1, rule 10 is at my instance for striking out defendant number 18
that has
because the
been kept
development
pending.
agreement has been cancelled. The development agreement which my learned friend is relying upon and placed before Lordship, that has been cancelled.
That has also been cancelled.
That has been cancelled. I would have submitted before Lordship.
So then what remains in the suit? Only partition.
Yes. They are constructing, Your Lordship. They are making constructions of
No construction. May I show the injunction commissioner's report once?
Then we'll pass an interim order restraining you from constructing.
So far
creating third party.
So far as the title is concerned, they are not entitled to any injunction. That much I can.
We'll refer the matter back to the trial court and ask the trial court to take into account all the documents and advert to those and pass a reasoned order.
Very well.
And we'll make it time bound and permit both of you no further documents, but time bound, both of you will be permitted to argue. After hearing both of you, rehearing both of you on the basis of the materials already on record, because you have already produced whatever you had to, we won't permit them also to produce anything else.
Gotcha.
On the basis of those materials, court has to decide.
Gotcha.
Now, if the court decides that there is probate, then court is at liberty to do that. But please don't make any construction or transfer in the meantime. We'll make it
There
time.
is no construction. The entire property has been demolished much ahead of.
Whatever
and
is
it is
there,
a vacant land now. Now it is a vacant. From the commissioner's report, I can show that there is no iota.
So the commission held also.
Yes, commission held.
So very well. Don't create any third party interest. And if the commissioner report is there, the court will have what is the status of the property.
May I just indicate to Lordship in one line of the commissioner's report?
Yes.
My Lord, may kindly see the commissioner's report at page 50.
Photograph, Shirana.
Kindly see.
Yes.
51.
Yes.
Point number 3. At present, the suit property is lying vacant and butted and bounded by old boundary walls, but it is evident there is a structure which has been demolished. At present, no construction work is going on in the suit plot. I have noticed that some bricks are stacked on the eastern side of the suit plot. I have also noticed 3 window frames fixed on the wall on the southern side of the plot. No building material like cement, chipstone, rods or machines are found.
There was only one instance which I know, that the commissioner went and actually found a stopcock not being operated, being stopped, so that no water is coming. That was the purpose of the inspection, to see whether the landlord is controlling the water supply. And it was actually found by the commissioner that the stopcock was stopped by the landlord. For that, my father's junior almost got sacked from his chamber, because he failed to inform his client that the commissioner was going. I have never found any local inspection report where it has actually been found that your people are making construction,
But
or you're
no
doing
material found. At least I can.
Kindly come to page
If
55.
no material is there, you are not prejudiced. Don't make construction.
I'm not prejudiced.
Page.
You're not prejudiced.
I am not prejudiced, but so
You
far
record
as
your
injunction,
submission that you are not
so far as injunction is concerned, my lord, I have a better title than the plaintiff, and I am in possession.
Either you have exclusive title or you
Exclusive
don't have
title.
title.
I have exclusive
There is
title.
no scope of better
Prima
title.
facie I can show here and now. I have an exclusive title.
Cannot have better title here.
Better exclusive.
Either by will you have only
Plaintiff
exclusive
and other
title.
defendants have no title at all.
Let the trial court consider this.
Lordship, kindly take page 55. There is another commissioner's report.
Another commissioner.
Yes, Your Lordship, I think he missed out.
But it was found that there were.
Yes, page 55, Your Lordship, kindly says. পরের date আছে দেখো মাদিকে date দেওয়া আছে
23/12 এটা আবার কবে কাজ
What is the name?
This is 3rd December.
that is
Third line kindly says নালী শিশু তপশীল বর্ণিত সম্পত্তি অনুমতি 30টি পিলার নির্মাণ করিয়া তথায় তৃতীয় অবসর নির্মাণ করা হয়েছে।
This is a sponsored litigation or?
No.
two commissioners.
What are the dates of the commissioners
Your
report?
Lordship, kindly, this is.
One is 11 July 24.
Yes, and page 55 is 23rd of December 2025. Order 39.
Why two commissions?
Because there subsequently another 39 Rule 7 application was filed.
By you?
By us. Because when, Your Lordship, the injunction was not granted ad interim, we filed Order 39 Rule 7 because they were contending that their construction was not going on. Finally,
Yes,
Your
Mr.
Lordship,
Password, do say to that.
If my lord may kindly see the initial order 39 rule 7 was on the by pursuant to order.
However, subsequent commissioner's report says that there is construction work going on. মিস্ত্রিরা কাজ করিতেছেন।
And page number 53 is the application, Your Lordship, schedule.
Pursuant to, I understand, but that was pursuant to the development agreement that was being made entered into, but that has been already been cancelled. I can show the deed of cancellation of the development agreement.
Show everything to the trial. Then you have to produce new documents. We'll have to give liberty to both sides.
Yes, that because they have relied upon the development agreement at the time of filing of the suit, but subsequent development is that development agreement has been cancelled, and I have sought for an expungation of defend number 18.
So my instruction is, Your Lordship, the construction has been substantially made.
If you say that, then there should not be any.
2018.
Not be any injunction. If it's substantially made,
substantial.
why would it be different?
No, Your Lordship, these particular pillars and everything has been constructed. That is, he's saying is a vacant land is completely incorrect.
We are deciding the appeal. We are remanding it as we said. The present appeal has been preferred by the plaintiff in a suit for partition and for declaration that a development agreement and for cancellation of a development agreement entered into between the defendants. First up, by the impugned order, the injunction, temporary injunction application of the plaintiffs was dismissed, primarily on the ground that the plaintiffs failed to prove their title and possession in respect of the suit property. First up, next parallel, counsel for the plaintiff/appellant submits. One plaintiff.
Yes, Your Lordship.
Plaintiff/appellant submits that along with the plaint, an elaborate genealogical table was furnished by the plaintiff to substantiate the fact that one Jagabandhu Bormon, who was at one point of time an owner of the suit property, had left behind on his demise several sons and daughters, including the predecessor in interest of the appellant and the other respondents. For sub next para, however, the impugned development agreement was entered into by the defendant numbers 1 and 2 by suppressing the existence of the said daughters of Jagabandhu, who were also co-sharers in the suit property. Full sub next para, it is submitted that by dint of admission of the title of Jagabandhu in the written objection filed by the said defendants, comma, implicitly the title of the present plaintiff and the other heirs of the daughters of Jagabandhu was also admitted. Full stop. Thus, comma, it is contended that the learned trial judge erred in law in refusing to grant injunction on the ground that the title of the plaintiff was not substantiated. Next para, per contra, comma, learned counsel appearing for the respondent numbers 1 and 2 argues that in the written objection to the temporary injunction application filed in the trial court, comma, it was categorically averred that certain wills were executed at different points of time by the different owners of the property, and ultimately, comma, by dint of such probated wills, comma, the property devolved upon defendant stroke respondent numbers 1 and 2, who in turn, comma, entered into a development agreement with third parties. Push up next para. Thus, comma, even without going into the question as to the plaintiffs and his predecessor and some of the other respondents claiming through the daughters of Jagabandhu could have been co-owners, comma, the said question loses relevance in view of the wills executed in favor of the defendant numbers 1 and 2. Full stop. Next para. Thus, comma, since the probated wills were produced in the trial court, comma, which were taken note of in the impugned order, comma, it is argued that the impugned order ought not to be interfered with. For the next para, we find from the impugned order, since arguable questions are involved, comma, we admit the appeal for hearing on the grounds taken in the memorandum and take it up for hearing along with the application in view of the short questions involved. Full stop. Next para, from the impugned order, comma, it transpires that the learned trial judge recorded that both parties had submitted within double inverted some documents, double inverted close, by way of firisti. Full stop. However, comma, none of the said documents were specifically adverted to, comma, nor were they mentioned in particular in the impugned order. Full stop. Next para. Throughout the impugned order, comma, which is cryptic in nature, comma, we fail to find any reference to any particular document, comma, including the probated wills, comma, copies of which were allegedly produced by the respondent numbers 1 and 2 before the trial court. Full stop. Next para. Fact remains that in the absence of any reference to any will, comma, there is no specific denial to the assertion of the in the plaint and the injunction application that Jagabandhu Bormon, comma, through whom the respondent numbers 1 and 2 claim the property, comma, had also left behind daughters, comma, through whom the other parties claim their title to the property. Full stop. Hence, comma, the very premise on which the impugned order was passed, comma, that is the plaintiff failed to show his title in respect of the property, was erroneous. Full stop. Insofar as possession is concerned, comma, we do not find any specific prayer for injunction in respect of possession. Full stop. Next para. Be that as it may, comma, it appears that the learned trial judge erred in law and in fact and proceeded in a perverse manner to dismiss the injunction application on the footing that the title of the plaintiff was not established and without referring to any of the documents produced by either of the parties. Full stop. Next para. Accordingly, FMA 731 of 2026 is allowed on contest, thereby setting aside order number 16 dated February 21, 2026, passed by the learned civil judge senior division at Bardwan district Poschim. Bardwan is Poschim, Purbo. District Purbo Bardhaman, in title suit number 136 of 2024 and directing both parties and their men and agents to maintain status quo as regards the suit property and direct and restrain both parties and their men and agents by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property in any manner whatsoever till disposal of the temporary injunction application in the trial court. Full stop. We also remand the injunction application to the trial court for a fresh adjudication on merits upon giving adequate opportunity to both parties of hearing as well as to produce further documents, comma, if the parties so deem fit and proper. Full stop. It is expected that such exercise shall be concluded at the earliest, comma, positively within 4 weeks from the date of communication of this order to the trial court. আচ্ছা এই লাস্ট পোর্শনটার আগে না একটা জিনিস we are adding something. It is also argued before us by learned counsel for both the parties that commissioners were appointed on 2 occasions and 2 commissioners' report were filed in the trial court. Full stop. However, comma, we find from the later commissioner's report on point of time that construction was apparently going on in the suit property at the time of inspection, comma, although the earlier report reflects otherwise. Full stop. Thus, comma, the court has to proceed on the basis of the last available commissioner's report, comma, construing that there was construction being made when the property was last inspected. Full stop. Next para. We must further note that the learned advocate for the respondent numbers 1 and 2 submits at this juncture that the development agreement, comma, which is the which is one of the primary bones of contention in the suit, comma, has since been cancelled by the respondent numbers 1 and 2. Full stop. We make it clear that all these questions will be kept open for the learned trial judge to consider at the time of rehearing of the injunction application, which we direct herein below. Thank you.
Regarding the construction, your lordship is not
Can 1 of 2026 is also disposed of accordingly, no rest to cause urgent certificate.
regarding the further construction, your lordship, if your lordship kindly make some.
Oh, আচ্ছা, yes. যেখানটা বললাম ওই restraint from and or changing the nature and character of the suit property as on today, as on this date. Thank you. Yes.
Appeal against an order refusing an ad interim injunction. The facts are slightly peculiar. This is not a dispute with regard to title. Admittedly, the defendant number 1 is a developer. He is developing a property of which the remaining defendants are the owners. Mine is I am a Section 8 company of owners of apartments and bungalows in a complex known as Money Towers. Order 1 Rule 8 suit, leave has been taken.
All right.
The defendants are carrying on construction on their own property. The effect of the construction is that the pillars of my buildings and my driveways are developing cracks. I say that if you are building on your property, I cannot have much to say about it except for the fact that you owe me a standard and a duty of care to ensure that your construction does not amount to a complete ruin of my property. The learned trial judge, the other aspect is, we said that the entire construction was being carried out in violation of all kind of norms of sound pollution, rules framed thereunder. The learned trial judge rejects the order of injunction. That is the order we are up against. Kindly, my lord, take the order in view.
That is the exact injunction you asked for, Mr. Bosu?
Kindly take
that they won't carrying on any work, excavation or piling, which would cause injury.
Yes. I tell you, Lordship, the problem is this. that plot has a large water body. The adjoining land is being constructed on. Displacement of the land is causing the crack. I just wanted to show you the photographs. There has to be.
Suppose the difficulty is, suppose even if you pass this injunction, how can it be implemented? It has to be ascertained whether there is any damage. It can be under the supervision of some engineer suggested by both of you, or some such sort of. Can we send it for mediation? This can be mediated. Why litigate? Both of you are rich people. You will become poorer after the litigation.
Clients.
Both of you. Yes.
May I take instruction?
It's a case for mediation, actually.
Filed an application under Order 26, Rule 9.
I have, but that,
and look,
I completely bow down to what your lordship has said. This is something.
is being heard on day-to-day
If we grant an injunction today, it cannot be implemented.
I tell you, lordship, the difficulty is that if you lordship once, if I can show you the photographs, the situation is horrific. We are here for 40 years.
We appreciate fully, but the injunction in the manner, either you have to stop the entire construction, which
lordship
probably,
if I am able to make out a case, your lordship will mold the relief.
you have no, it's not molding. It's more than beyond your prayer. That's the difficulty. It could be the other way around. It would be molding. If you wanted blanket injunction and we said no without creating damage, you have asked for injunction without damaging. They have to make. I mean, they cannot make construction by damaging. So you have asked for a lesser relief. We cannot expand that. We could have molded down, could not mold up. So therefore, and proper injunction, but how can we implement that? Tomorrow you will file a violation application, contempt application, and then the injunction, then the inspection will occur. I mean, before that, have a local investigation and we'll direct the trial court, because we can say that this will not, this is tentative only, this will not affect the trial court at the time of final hearing.
We have filed. They have
That
filed
will
an
dispose of-
application. They have also filed an application in the court below under Order 39 saying we are trying to
39(7).
39 1 and 2 saying we are trying to prevent the construction, which is right now there is still an embargo by the corporation unless they can show that they have obtained the clearance from the corporation to construct. So that's really a method to get around that. So that is
Name a
it's real.
mediator, we'll appoint a mediator. We let it be a court appointed mediator.
I'll
Mediator.
keep it as to be mentioned tomorrow, my lord. I'll take
Yes, yes,
instructions.
take
as well.
instruction, both of you. Not tomorrow. You'll need some more time. Or tomorrow we can keep. We have no.
We have no objection because, Lord, we have all the permissions. We have disclosed all these documents.
Yes, this is a fit case for mediation by someone who has some idea of this real estate or whatever, this sort of litigation or a commercial litigation.
And in
Not
fact,
people
the
like us.
lower court.
Actually, I mean, someone who has some idea of this and
That's true.
please agree to someone if you can. If you can't, suggest names. We'll select, we'll understand what sort of mediator you are wanting and we'll appoint somebody of similar.
But in fact, tomorrow the matter is fixed before the court below.
That can await if we are
Big matter is going on, and in the meantime, we can.
No, let the injunction proceed and the 26(9) proceed, Mr. Bose. That will help you only.
Yes, yes.
If in the meantime,
tomorrow.
yes, if in the meantime that is allowed, or I mean, if they
Coming
oppose, that will
Monday-
be a good ground in this appeal.
No, we are not opposing. Okay, that's what my solution was. That let
Exactly.
26(9) go through.
This is not a litigation that should go to trial. It should be settled.
Exactly.
Because
Exactly.
I don't deny that they have a right to construct, but they also don't have a
And
right
this
to
is a
destroy.
very fair prayer which we see. I mean,
Yes.
we may not grant it. It's impossible to implement maybe, but it's a very fair prayer. You don't ask for something.
No, how can
You-
I
you-
prevent him from constructing on his own land? The only thing is that he can't
You have not
destroy
done
my
that.
property.
This is
Obviously, obviously it will fall from it. The present dispute pertains to an allegation that the respondents are making constructions which are detrimental to the safety and security of the existing structures belonging to the members of the appellant you're an association, appellant society.
It's a Section 8 company.
Acha, appellant company. Full stop, next para. From a perusal, upon hearing learned counsel for the parties and from a perusal of the materials before us, it transpires that the matter is fit to be settled by mediation by a competent mediator. Full stop, accordingly, we request both parties to take instruction as to whether a mediator stroke mediators can be agreed upon to resolve the dispute between the parties, full stop, for such purpose, comma, let the matter be listed tomorrow under the heading to be mentioned. Tomorrow or day after tomorrow?
Could it be on Monday if it is not?
We'll keep it on Monday.
Yes, yes.
It may take some time to decide. On August 10, 2026, as to be mentioned.
Yes, your lordship rises. I have got a humble prayer, my lord, with regard to 57 and 61.
Yes.
Actually, there is a bereavement in my family. That is why I
Pardon,
have-
pardon, please use your mic.
There is a bereavement in my family, my lord.
Oh,
That is, I have to go to my native village. My lord, my junior will, my lord, mention this matter. 57 and 61. When
when
it
they
will be
when they
called?
mention the matter, ask
Yes,
for
sir.
adjournment. Just tell them to
Yes, yes.
cite the reason why they're asking for this.
That is why I am mentioning.
And you can please inform the other side also.
Yes, yes.
Thanks.
I'm deeply obliged.
Thanks.